item have been taken up today, my lord. It was in the last week. It was in the list, item number 21. It was passed over, but due to paucity of time, my lord, it could not be taken up. And it ought to have been come in the leftover matter, but it has not come. And it is straightway it has come in the 300, item number 300. Urgency, my anxiety is, my lord, the 3 SC/ST Act is involved, and your lordship given notice to the victim, my lord. So the informant manipulating the Vakalatnama has filed it and trying to delay the protracted the matter. This matter will be taken up today, madam.
Yes, next.
Item 153, fresh bail under SC/ST Act. Notice may be used. 153.
Notice has not been issued.
No, my lord. Fresh matter.
That is CRLA 884 of 2023.
Guru Prasad Chandi was.
Alright, issue notice. Extra copy to be served. CD and criminal antecedent to be obtained. We commencing from 11th of September 2023. Yes.
Pardon, my lord. Item number, at least item number 207, kindly taken up today.
Yes,
Lordship, item number 152. Application under section 15 of SC Act.
100?
152. 152.
152.
That's it.
It's a fresh matter.
That's it.
There is one defect number 9. What is the defect? देखिए कौन पूछिए. अच्छा, good ground certificate not furnished. Same order कर दिया तो previous time ना extra copy. Notice CDCA. Defect to be removed in the meantime. Yes.
Pardon to make a mention, my lordship. Item number 315 must have come under admissions, but have come under orders.
All right. Yes. Next.
Item number 248, my lord. It's a bail application, my lord. Bail application. So kindly taken out 5th September, my lord.
Yes.
Well, item 171, you see. File a interim order, my lord. Your lordship granted interim order earlier due to his medical problem, my lord. The 1 month period, he could not arrange the money and could not operate the use.
So what?
So I filed, my lord, another bail application, interim bail.
All right.
Can it be taken up?
All right. When it reaches, it will be taken.
Item 230, my lord. It's a 3 SC Act, my lord. And the bail also 230, my lord. And penal petitioner was released on bail on the ground of his father was expired, my lord. And thereafter he surrendered, my lord. Offender 506, 354, 3 SC Act, my lord.
Notice has not been
issued. Yes, served, my lord. Notice issued, my lord.
All right. When the matter reaches, we'll take up. Yes.
My lord, pardon to mention tied up matter, my lord. 2 tied up matter.
One CRLA 780 of 2021 for bail.
Give it.
Supplementary list, item number 2.
Yes.
Made, please.
What are your grounds for stay of conviction?
Well, number 1 is the conviction is based upon a material to which the accused was never confronted with in a 313 statement. Conviction solely based upon those 3 materials.
What is your written note of submission?
I have given ballot.
What is that?
Lordship just sees ballot. If Lordship may take up my written notes of submission, ballot. Lordship kindly come to in up to paragraph 3, my lord. I have given just cited the judgments and the relevant portions.
I may not trouble your lordship with that. Lordship can come to paragraph 4.
That is also another judgment.
Yes, that judgment, my lord, the portions I have highlighted, my lord, that are quoted from my lord's judgment, the Sri Hari Charan Das versus State of Orissa Vigilance. Judgment delivered by your lordship on 4th of July. The portions I have highlighted, my lord. The petitioner stands for a fair chance of acquittal, and he has made out an exceptional case which convinces the court to exercise jurisdiction 389, my lord. Therefore, the reading of all the above judicial pronouncements ultimately limits the scope of exercise of power under Section 389 CRPC to the extent where the petitioner stands for fair chance of acquittal, and it makes out an exceptional case to convince the court. Therefore, the instant case, the petitioner has to establish that he stands for a fair chance of acquittal, my lord. In para 5, my lord. To establish the above, the petitioner submits that the conviction has been arrived at by the learned trial court solely on the basis of Exhibits 38, Exhibit 18, and Exhibit C1, pages 53 to 56 of the brief, and internal pages 24 to 27 of the trial court judgment. While dealing with the above 3 exhibits, the learned trial court observed that the vigilance officer entertained doubt regarding correctness of the entries dated 16 July 2008, 17 July, 18 July, 19 July, 20th July 2008 in the stock registered Exhibit 18. While dealing with the same, the learned trial court dealt with the opinion of the government examiner, that is Exhibit 42, who had opined that the signature of the petitioner on the admitted documents tallied with the signatures on the statement of the progressive delivery, Exhibit 38, and stock register Exhibit 18. The learned trial court further observed that the examiner could not furnish any definite opinion. The learned trial court also held that the entries regarding return of the specific quantity of the CMR for improvement as mentioned in Exhibit 38 was not proved by the examiner to be that in the handwriting of the accused number 1, and therefore the learned trial court jumped into a conclusion on the basis of the assumption that it is crystal clear that there has been manipulation, correction, and insertion of the words, expressions, and figures. The learned court below further held that when Exhibit 18 was maintained by the accused number 1, he is the best person to say as to how such type of manipulations and insertions were made in the relevant entries. The accused number 1 has not referred the doc to explain the above circumstances. While holding such, the learned trial court tried to observe that after closure of the evidence on both sides, while perusing the record, it came to his knowledge that one document closely similar to Exhibit 38 was available on record and was marked as Exhibit C1. While comparing this document with Exhibit 38, the learned trial court found that the printed part of Exhibit 38, wrongly typed 31, 38, is same as Exhibit C1, which appears to have been copied from the original by Xerox process. Then the learned trial court jumped to the conclusion that in this document there has been no insertion or interpolation, and based upon said document, the trial court found the petitioner guilty. Such a finding under no circumstances be said to be confirming the provisions of the statute, especially Section 313. The learned trial court in para 3 of the judgment has only dealt with Section 313 CRPC to reflect that the accused number 1 has stated that he has not violated any guideline on his report. Criminal cases were instituted against the accused millers. The accused number 2 and 3 stated that they have already returned the resultant price for whatever the paddy they have received. Otherwise than this, the learned trial court has not dealt with the accused statement recorded under Section 313 CRPC in the entire judgment. The accused statement is filed herewith for reference of this honorable court, and from the accused statement, it can be well seen that the accused has not been put any question with regard to Exhibit 18, Exhibit 38, and Exhibit C1, except in question number 60, whereon a question, it appears from the evidence of PW 18, Mr. Ajit Kumar Das, the then government examiner of question document at the Directorate of Vigilance, that on 6th of April 2011, as per the requisition Exhibit 36, received from the DSP Vigilance, Bhavanipatna, he submitted his opinion report via the Exhibit 41 as an expert relating to the entries made in the stock register. But this is what has been put in entirety. The petitioner has answered in negative. There has been no specific question with regard to alleged manipulation, interpolation in Exhibits 38, 18, and further. The accused statement does not whisper about Exhibit C1, based upon which the order of conviction has been passed. Law is fairly well settled with regard to the provisions under Section 313 CRPC. It is reported in so-and-so case.
Exhibit C1 when it was proved?
Blood. It was never proved, blood. Blood, this is the document which came to the light. Well, let me take your lordship to that particular portion of the judgment.
Exhibit C1 means it's a court document.
Lordship may just seize that in the judgment. Yes. Your lordship will get it at Millard, page 50. Let me take it lordship to page 54 of the judgment, Millard. And
that particular document is a document which is exhibited on behalf of the court.
This came to the light of the learned trial court while Millard dealing closely, dealing with the Exhibit 18 and 38. It was never put to. Lordship may just see that on page 55, running page 55, internal page 26 of the judgment, Millard. I'm just reading out, Millard. In this context, I would like to know. Yes, Millard. The sentence starts from page 54, last line, Millard. In this context, I would like to note that after closure of evidence from both sides, while perusing the record, it came to my knowledge that one document closely similar to Exhibit 38 was available on record and was marked on behalf of the court as Exhibit C1.
When that document was marked as an exhibit?
Millard, it was never only while Millard, the learned trial court was dealing with the matter of the closure of evidence, Millard, it came to his notice, and thereafter, Millard, such a thing has been stated in the judgment. Millard, I have give. Say that.
C1 देखिए
मोटे कॉपी ऑफ एग्जिबिट अलग देखिली मैंने इन आ गोटे मोटे कॉपी दोची
503 that was marked on 15/10/2022 without objection. Order sheet of 15/10/22 कर लें.
Millard, the accused statement was taken on 14th July 2022, Millard.
The case record is put up today on the strength of an advance petition filed by the advocate for the accused Manoj Pradhan, serving a copy of the same on the learned public prosecutor. The learned advocate for the said accused has also filed a petition under section 243 CRPC along with some documents with a prayer to refer the same. Hard on the petition from the learned advocate, the case has been posted for judgment. After a lengthy hearing, no prayer is made to admit the documents filed with the petition as evidence, and the documents can neither be marked as exhibit nor referred for preparation of the judgment. However, as submitted by the learned advocate for the accused, the documents may be kept on record The petitioner is accordingly disposed of. The learned special public prosecutor and the learned advocate for the accused have filed written note of submission and memo of citation. The same be tagged with record. While perusing the record, I find that some relevant documents kept in record since long have not been marked as exhibit by either party. Out of same one sheet of paper having close link with the vital document is marked as exhibit C1. Accused persons are directed to remain in present. When the accused statement was recorded?
My lord, it was on 14th July 2022, my lord.
The argument was closed on what date? Well, 2022. Argument closed and posted for judgment. So 2022, 10, 2022. Okay. So what is the finding of what you are saying that he has relied upon 3 documents to convict you?
My lord, this is at the page 55. It starts from 54, my lord.
Come to the judgment.
Lordship, can you come to page 53?
53.
But just before, one more aspect also. Before placing this particular part, because based upon these 3 documents, conviction has been made, my lord. One more aspect, my lord. Well, in fact, there are 2 places, my lord. 2 areas. One is Kusum Khunti, my lord. Another is Ladugaon, my lord. But the sanction was for Kusum Khunti for alleged misappropriation of 1,44,000, my lord. But well, the entire case has gone, my lord, on the basis of 1,44 lakhs, which is for Ladugaon, my lord. And there is no sanction.
You have not dealt with that point in your written note.
Yes, I have dealt with, my lord. I have dealt with.
No, first clear out. You said that it is based on 3 documents. I am now going
Yes,
to that.
okay. No, let me clear this part, then I'll come to that part. That is there in the written submission, my lord. In the written submission, I have not left any stone unturned, my lord.
Where is that?
My lord, written submission, my lord.
No, the judgment finds.
My lord, it is.
That
Lordship may kindly come to page 53.
Yes.
The 8th line from the bottom. A question arose. Lordship, what you mean? A question arose as to whether the accused, number 1, made the corrections and entered the relevant facts in Exhibit 38. The vigilance officer further entertained doubt regarding the correctness of the entries.
Who is accused number 1?
Well, let me.
Okay.
The vigilance officer further entertained doubt regarding correctness of the entries on 16 July, 17 July, 18 July, 19 July, 20 July 2008 in the stock register of the rights Exhibit 18, and therefore the same along with some admitted signatures and the handwriting of the accused were forwarded to the government examiner of the question documents at Director Vigilance Cuttack. The opinion report of the concerned examiner has been marked as Exhibit 41. The statement of reasons in the support of the opinion has been marked as Exhibit 42. On the conjoint reading of the above exhibits, I find the government examiner QD has opined that the signatures of the accused number 1 on the admitted document tallied with the signature of the statement in the progressive delivery Exhibit 38 and the stock register Exhibit 18. So far as the correction of the date of entries in the above noted dates of stock register, the examiner could not furnish any definite opinion. In stock register, there is mention of one expression returned stock just above the entries of the quantity of the rice. The said writing was, however, proved to be in the handwriting of the accused number 1. The entries regarding a return of the specific quantity of the CMR for improvement as mentioned in Exhibit 38 was not proved by the examiner to be that in the handwriting of the accused number 1. Therefore, it is crystal clear that there has been a manipulation, correction, and insertion of the words, expression, and figures. When Exhibit 18 was maintained by the accused number 1, he is the best person to say as to how such type of manipulations and insertions were made in the relevant entries. The accused number 1 has not referred the doc to explain the above circumstances. In this context, I would like to note that after closure of evidence from both sides, while perusing the record, it came to my knowledge that one document closely similar to Exhibit 38 was available on record and was marked on behalf of the court as Exhibit C1. While comparing this document with Exhibit 38, I find the printed part of Exhibit 38 is same as in Exhibit C1, which appears to have been copied from the original by Xerox process. In this document, there has been no insertion or interpolation. As per this document, the statement was for the period ending 1st June 2008, and the accused purchase officer put his signature on 4th June 2008. It is peculiar to note that there is short signature of someone with the date of 24th October 2008 in C1 on the C1, and the similar signature with the said date is available in bunch of unexhibited documents, which are prepared during the time of surprise inquiry by the vigilance on 23rd, 24th October 2008 in the presence of the officers of the Civil Supply Department and Commercial Tax Department. It indicates that Exhibit 38 was not in existence by the date of surprise inquiry. It may be mentioned here that the sanctioning authority in the sanction order Exhibit 50 has already formed an opinion on perusal of the documents placed before him that the recording of return of stock in stock register Exhibit 18 was afterthought, as there has been handwriting over the computerized report. It is not the case of the accused number 1 that the handwritten entries on Exhibit 18 and 38 were made by anybody to the detriment of his interest or that anybody in custody of the said document had any foul intention in making such entries. Rather, if he relied on the said entries to prove his plea of defense. It is therefore crystal clear that the Exhibit 38 was subsequently manipulated by the accused number 1 himself or through his agent, and the entries in the rice stock register were also subsequently inserted to suit the explanation of the accused number 1, which I gave before the team of members, including vigilance officer, who conducted the surprise inquiry on 23rd and 24th of October 2008. When the accused number 1 himself does come forward to explain the discrepancies and the incriminating facts and circumstances as described above, which are within the exclusive knowledge, it would be just and proper to hold that he forged the official documents partly by himself and partly through some others for some ulterior and illegal motive. It appears the accused wanted to clean his skin and throw mud upon accused number 2 and 3 by fabricating false documents and making false allegations against them. There is absolutely no proof by independent documentary evidence that the accused number 2 and 3 received back the stock of CMR for improvement, as claimed by the accused number 1. Therefore, the allegation of the prosecution regarding forgery of record and falsification of account relating to the CMR received by him are well established. However, the prosecution has not placed any admissible evidence to that effect that the accused number 1 made the aforesaid forgery at the instance of or in the connivance of the accused number 2 and 3. The accused number 2 and 3 are proved to have committed forgery, are not proved to have committed forgery or falsification of any document. Well, your Lordship has seen how Exhibit C1 came into was surfaced, and nothing in the 313 statement with regard to Exhibit 18 and Exhibit 38.
Where is that accused statement?
My Lord, I have given to your Lordship a copy. I have given my Lord at question number 60.
Accused statement. Have you given a copy?
Yes.
To Mr.
Yes.
Accused statement को question ने पचराई जी
Sakye.
এই তিনটা ডকুমেন্ট C1 তো পଚରା ହେଇନଥିବ କାରଣ
ନା ନା C1 ପଚରା ହେଇନି।
C1 ଟା ପୁରା ଜଜମେଣ୍ଟ ରିଜର୍ଭ ହେଲା ପରେ ସେ ଆଡମିଟ
ହଁ,
ମାନେ ମାର୍କ କରିବେ।
କେବଳ 36 ବିଷୟରେ ପଚରା ହେଇଛି।
ନାଇଁ ନାଇଁ 18 ଆଉ 38 ଏଇ ଦିଟା
18 ଆଉ 38
ଏ ବିଷୟରେ କୋଉ କ୍ୱେଶ୍ଚିନ୍ ଟା, କାରଣ ସେଇ ଦିଟା ହଉଛି ମେନ୍ ଡକୁମେଣ୍ଟ ଯାହା ପଢିଲେ ସେଥିରୁ ଜଣା ପଡୁଛି ସେ ଦିଟା ହଉଛି ମେନ୍ ଡକୁମେଣ୍ଟ ଯୋଉଟାକୁ ୟୁଟିଲାଇଜ କରାଯାଇଛି ଫର କନଭିକ୍ସନ।
ଷାଠିଏ ନା 60ରେ କେବଳ 36 ପଚରା ହେଇଛି।
18 ଅଛି
36
18 ଆଉ କିଛି ନାହିଁ।
60ରେ ପଚରା ହେଇଛି ଏକ୍ଜିବିଟ୍ 36 PW18
ନାଇଁ
ଏକ୍ଜିବିଟ୍ 18
ହଁ
ଏକ୍ଜିବିଟ୍ 18 ଟା ଅଛି ଷ୍ଟକ୍ ରେଜିଷ୍ଟର 18
କୋଉଟା କୋଉ କ୍ୱେଶ୍ଚିନ୍ ଟା 18 ଉପରେ କୋଉ କ୍ୱେଶ୍ଚିନ୍?
क्वेश्चन नंबर 60
60 वाला
60
yes
60
ଟିକେ ଟିକେ ରୁହନ୍ତୁ। 18 ଏଇଠି ଅଛି। ହଁ କଣ କ୍ୱେଶ୍ଚିନ୍ ଟା ପଚରାଲା? It appears from the evidence of PW18 Ajit Kumar Das, the then government examiner of so and so, at the director that on so and so, as per the requisition submitted by, he submitted the opinion report exhibit 41 as an expert relating to the entries made in the stock register. What have you got to say? Janini.
only this much.
ये आसिक जो accused जोटा underline करती judgment
No hair ballot out of 62 questions accepting
Yes,
this.
yes. Mr. Das,
Ballot. Oh,
his
sorry.
submission is that when you have utilized mainly 3 documents apart from other things, 18 गोटे 38 गोटे और C1 टाको मार्क कले जजमेंट रिजर्व रहला तारी बळे मार्क कर देला। तो ऑब्वियसली ता पई क्वेश्चन नाही। बाकी 18 और 38 जेते बळे आपण फाइंडिंग दउछंती जे 18 और 38 रे मैनिपुलेशन सेछि इंसर्शन हेछि ताले गोटे क्वेश्चन पचारियार नथिला अक्यूज स्टेटमेंट रे जे एग्जिबिट 18 और 38 होछि आपणकर हैंडराइटिंग आपण ताकू मैनिपुलेट करिसंती इंसर्शन करिसंती कोन आपण कहिवार अछि से केमत कोठी एक्सप्लेनेशन देबे ताले ताकर आउ स्कोप कोठ आइला you
ସେଇଟା
find
exhibit ଟାକୁ ଲେଖି ନାହାନ୍ତି exhibit has not been particularly asked
नै कोनादी इनडायरेक्ट भी कोठी कुहाई छी कोनादी से तो कहउछन से जे एग्जिबिट 30 18 टा होछि व्हाट इज द एग्जिबिट 18
Stock register ballot.
एग्जिबिट 18 होछि स्टॉक रजिस्टर और 38 टा कोन
38 ballot is the statement showing the progressive delivery of paddy.
statement showing progressive delivery of paddy
Yes.
अच्छा ठीक था डॉक्यूमेंट को धरंतु रेफर कलेनी ताले एतिक एटलिस्ट पचार थांते जे आपण ए जो स्टॉक रजिस्टर मेंटेन करथिले ता धीरे आपण मैनिपुलेशन और इंसर्शन करिसेंती बेली एई साखींकर अभियोग आछि एमती किछि क्वेश्चन पचराइछि
51 नंबर रे पचरा ହେଇଛି
51 नंबर रुंत आसीबा ए 51 नंबर बाहर करो क्वेश्चन तो वाक्य स्टेटमेंट जोटा जो हां हां पछांतु it appears from his evidence that after verification of the stock register and other relevant document it was ascertained that there was a shortage of rice of more than one son. So far as Mrs. Jaya is concerned, what have you got to say? Admit କରୁଛନ୍ତି ଆପଣ
43
admit କରୁଛି ଯାହାକୁ ଦିଆ ହେଇଛି ଯୋଉ
43
ମିଲର କୁ
question number 43
5143 ହଁ କୁହନ୍ତୁ
It appears from the evidence of PW 13 Vishwajit Chatterjee, Senior Account Supervisor in OS CSC Limited, Bhavanipatna, that on 19/10, as per the direction of the CSO, he produced 24 numbers of documents like stock register, purchase register, procurement registers, stock issue registers, acceptance notes, gate pass, delivery challenge, etc. And the same are seized by the vigilance authorities under seizure list by Exhibit 3.
ନାଇଁ ଏଇଟାରେ କିଛି କହିପାରିବେନି ସେ ମାନେ ସ୍ପେସିଫିକ କ୍ୱେଶ୍ଚିନ୍ ହବା ଦରକାର ନା a particular document it was maintained by you and it has been there has been manipulation of ଇଏ ତାହେଲେ ଆପଣ opportunity ଦେବେ ଆଉ ସିଏ ଅମକ ସାକ୍ଷୀ ଏଇ ଡକୁମେଣ୍ଟ ଗୁଡାକ ସିଜ୍ କଲା ସିଏ କହିଲା ମୁଁ ଜାଣିନି ଠିକ କହିଛି ସେ ମୁଁ ଜାଣିନି এইটা you are right ସେ ଯୋଉ କୋଉଟା ଦେଖେଇଲେନି 51 টা to some extent
that is 51 that Jai Hanuman is an accused accused number 3 my lord and the against criminal case is pending.
It appears from his evidence that after verification of the stock register and other relevant stock register भी कितना stock register प्रमाण है जदरे
only one exhibit 18 is only one
and other relevant document it was ascertained that there was shortage of rice of more than so far as Jaya Hanuman rice is concerned. It भी actually ये जो question हवा का था जे verification of the stock register it is found that you have maintained that and that is found ମାନେ ଏଇ ଟାଇପ ର ହେଲେ ସେ ଗୋଟେ explanation ଦବ either deny କରିବ କି ଗୋଟେ କଣ explanation କରିବ ଆଉ
let exhibit A E exhibit E is an order of the collector Kalahandi Bhavanipatna that order is at the behest of that Jai Hanuman Malad in that Jai Hanuman admits that he repolished the rice. He, however, contends that on repolishing the rice rice had crumbled to dust and half of it had gone waste. The petitioner, that is Jai Hanuman, could have brought it to the attention of the Civil Supply Limited immediately after repolishing one lot, but he did not do so. He continued to repolish the entire lot and after allegedly losing nearly 2,300 quintals of rice worth 35.7574 crores, now prays that the amount be waived.
So, Mr. Das, ମୁଁ ଜାଣିବାକୁ ଚାହୁଁଛି ଯୋଉ ବର୍ତ୍ତମାନ ସେ କଣ୍ଟେନସନ ଟା ରେଜ କରିଛନ୍ତି ସେ ଭାଇଟାଲ କଣ୍ଟେନସନ ଦ୍ୟାଟ ତିନିଟା ଡକୁମେଣ୍ଟ କୁ ବେସ୍ କରିକିନି ଯେ ଆପଣଙ୍କର ହ୍ୟାଣ୍ଡ ରାଇଟିଂ ଏକ୍ସପର୍ଟର ଓପିନିଅନ ଉପରେ ଫାଇଣ୍ଡିଂ ଆସିଲା ଯେ ଏଥିରେ ମ୍ୟାନିପୁଲେସନ ହେଇଛି ଇନସର୍ସନ ହେଇଛି ଏବଂ ଏଇଟାକୁ ଆକ୍ୟୁଜ୍ଡ ହିଁ କରିଛି ଆକ୍ୟୁଜ୍ଡ ନମ୍ବର 1 ମାନେ ଏଇ ପିଟିସନର ବା ଆପେଲାଣ୍ଟ ତେଣୁ obviously these are material documents and the findings have been arrived at relying on these documents. So whether it was necessary or not on the part of the court to put question to the accused on these three documents to offer to give him a chance to explain that she with a deny करथांदा बा से कहिथांदा आज्ञा मु एउडा करनी ये हैंडराइटिंग हम करो कि जहां भी गोटे ଆପଣ ସେମିତି ଡାଇରେକ୍ଟ କ୍ୱେଶ୍ଚିନ୍ ହଉ କି ଇନଡାଇରେକ୍ଟ କ୍ୱେଶ୍ଚିନ୍ ଆପଣ ତ ଏଇ ଯୋଉଟା ଦେଖେଇଲେ 51 ନମ୍ବର ତା ଦେହରେ ତ ସେ ଇନସର୍ସନ ଅମକ ସମକ କିଛି ନାହିଁ ଖାଲି କୁହାଇଛି ଯେ ଯୋଉଥିରୁ ଜଣା ପଡୁଛି ଜୟା ଇଏକୁ 5,900 କ୍ୱିଣ୍ଟାଲ এটা ଟିକେ ଭେରିଫାଏ କରନ୍ତୁ କାରଣ ଏଇ ଫାଇଣ୍ଡିଂ ଗୁଡାକ ଆପଣଙ୍କୁ ସେ ଦେଖେଇ ସାରିଲାଣି ଜଜମେଣ୍ଟ ର
May I submit one thing?
Yes.
Your Lordship may kindly have a glance to the petition itself under section 389, which at flag C.
389 कौन वाला दिखा? Petition का
The petition under section 389.
IA number कितने?
IA number 1993.
कौन?
Your Lordship may kindly refer to page 25 of that petition.
25.
This appellant petitioner filed this application on 21/11/2022. I have filed the memo that he has been dismissed from service since 16/11/2022. Nothing has been added in this application regarding his dismissal from the service. Now, whatever has been added in this application as well as the written note of submission, all those relate to the merit of the appeal, my lord. As your lordship have observed, I have filed the citations. Your lordship may kindly have a glance to the citations at flag G and H. Your lordship may kindly have a glance. And it has been categorically held by the Honorable Apex Court of the country that all these merits and demerits will, while considering under section 389 application, all these aspects will have to be considered at the time of final hearing of the appeal, but not at this stage, my lord. Your lordship may kindly have a glance to H, flag H. I have filed all the decisions, including your lordship's decision, and my learned senior was arguing one case. My learned senior was arguing one case, and it has been reported and it has been passed by your lordship, Pradeep Santi. I have also filed the decision. Pradeep Santi. Your lordship has categorically observed that after carefully analyzing the finding of the learned trial court, the submission made by the learned counsel for the respective parties and evidence on record at this stage, it cannot be said that it is a case of no evidence against the petitioner. Whether the evidence available on record would be sufficient to uphold the impugned judgment and order of conviction of the petitioner, or on the basis of points raised by the learned counsel for the petitioner, benefit of doubt is to be extended to the petitioner is to be adjudicated at the final stage when the appeal would be heard on merit. Giving any finding on the merits of the case is likely to cause prejudice to either of the parties. This court will certainly have a duty to make deeper scrutiny of the evidence. So, your lordship's observation.
Objection re se decision guda ko su jo rely करछंती.
Yes, my lord.
तार citation अवश्य आपण देई नथियो.
देछि ना. सेटा before that was listed before honorable bench in court number 11. So, सेठी मु सब जाक फाइल कर देइथिली. G टा दियंतु तापर H टा दियंतु. सब जाक फाइल कर देइछि.
ना ठीक अछि.
सब जाक G and H F and G. So G टा my lord को रेफर करछि एई पई एटा लाटेस्ट फाइल करछि. G टा रे your lordship may kindly refer to page 98. G रे
page 98.
Yes, my lord. Paragraph 33.
98 सेम कोन पेज नंबर आपण देइ जंदी माने प्रथम डिसिजन
ना G रे एटा होची ओम प्रकाश. ओम प्रकाश साहनी. Your lordship got it. ओम प्रकाश साहनी. 2023 91 OCR Supreme Court page 84.
80.
Page 98. 33 रो last sentence टा. The appellate court should not reappreciate the evidence at the stage of section 389 of the CRBC and try to pick up few lacunas or loopholes here and there in the case of the prosecution. Such would not be a correct approach. 34. In the case in hand, what the High Court has done is something imperceivable. High Court has gone into the issues like political liability, delay in lodging the FIR, some overwritings in the first information report, etc. All these aspects will have to be looked into at the time of final hearing of the appeals filed by the convicts. On cursory scanning of the evidence on record, we are unable to agree with the contentions coming from the learned senior counsel for the convicts that either there is absolutely no case against the convicts or that the evidence against them is so weak and feeble in nature that ultimately, in all probabilities, the proceedings should terminate in their favor. My lord, this is a last decision. Hence, and also I rely on your lordship's observation in so many decisions reported. Last decision is Pradeep Shanti, and your lordship, our own High Court's decision I have relied on. I have cited all the starting from K.C. Sarin. So now at this stage, whatever has been submitted by my learned senior in the application under section 389 as well as in the written note of submission, all those relate to the merit of the appeal matter. So no exceptional circumstances has been mentioned in this application after dismissal from the service as to whether in the event your lordship stays the conviction, whether you will be reinstated in the service.
No. One thing, please answer me. He has stated that these are three vital documents. Two have been proved on behalf of the prosecution. One is marked on behalf of the court. And these documents show that the appellant has manipulated or overwriting all these things, which these three particular documents show. And the very pertinent line is that the accused has or the appellant has failed to explain how these insertions have been made. So when he will explain, how he will say, unless those questions are put to him under 313 statement referring to those particular documents, that from these documents it appears that you have made manipulation, you have made insertion in these documents. Unless these questions are put specifically, how can he explain, which you have ultimately has said that he has not explained. He has nothing said about how the manipulation has been done. So that is why accused statement is there to give a fair chance of hearing to the accused to have his say. And law has gone to the extent that unless on a particular circumstance, unless a particular document, a question is not put in the 313 statement, that circumstance or that document cannot be utilized against the accused. So to that effect, law is clear. So here it goes to the root of the case. Your recording of accused statement can be said to be faulty when you are omitting those three documents and not putting any questions on those three documents in the accused statement. And basing on those three documents, you are suppose it would have been a case that apart from those three documents, let us say that those three documents have not been put, but there are other materials on record to prove the guilt of the accused. Matter is different. But when you are relying on these three particular documents,
my submission before your lordship that all these documents which your lordship referred to, and it has been categorically discussed by the learned trial court in the judgment, and also on it has been perused under section 73 of the Evidence Act by tallying exhibit code C1 and 38, and came to the opinion.
No, court has tallied.
Yes.
The chemical examiner, the handwriting expert is there, manipulation.
Yes. All these
things are there.
Only if at this stage it will be decided for the 389 CRPC, will it not impact the merit of the appeal in the future, my lord? My submission is before your lordship that if these factors will be taken into consideration at the stage of 389 application for stay of conviction, will it not impact the merit of the appeal at the stage of final hearing of the appeal, my lord?
Okay. Yes, any other submission you want to make?
Yes, my lord. Lordship, kindly come to page 10 of my written submission.
Written submission.
Well, in fact, the place where I had left Ballard at page 7, from paragraph 9, 10, my lord, these are all the citations, my lord, with regard to section 313. I'm just skipping it over, my lord. Lordship, kindly come to page 10, my lord. Para 11.1. Lordship with me, my lord?
Yes.
In the incident case, the sanction order exhibit 50, which speaks of the sanctioning authority according sanction for prosecution of the petitioner concerning the alleged misappropriation of the rice amounting to 1,44,747 from RRC Kusumkunti. And admittedly, there is no order of sanction for RRC Ladugaon. When there is no sanction for RRC Ladugaon, the petitioner could not be convicted for any kind of allegation concerning the said RRC. Para 11 of the impugned judgment deals with the misappropriation of only 1 crore 44 lakhs, which is the alleged misappropriation amount of misappropriation for RRC Ladugaon, not Kusumkhunti, for which the sanction has been accorded. And the whole of the judgment thereafter deals with the alleged misappropriation of 1 crore 44 lakhs, which finds place in para 14 of the impugned judgment in para 58 of the brief, internal page 29. Therefore, when there is no sanction for any alleged misappropriation concerning RRC Ladugaon, there could not be any conviction without according of sanction for the said RRC. The alteration of charges aspect has been dealt with by the learned trial court in para 6 of the judgment, and in the said para, the learned trial court held that in the charge, there is a clear mention about misappropriation of 9081.71 quintals of rice, and the cost of the same would be 1,44,000. But the order dated 13th of July, the words and figures of the amount of misappropriation was changed to 1 crore 44 lakhs. The said correction was made on the basis of the prayer of the special PP, who pointed out that it was an arithmetical error. By considering the same, ultimately the trial court held that the correction in the charge is a mere rectification of a defect in the arithmetical calculation and nothing more. Well, this is absolutely without base. It is a finding which not only can be said to be perverse, but now there is nothing to establish this.
Well, the sanction order is marked as
50, exhibit 50, my lord, 50.
देखिए sanction order.
It is legend.
Exhibit 50 টা দিলো
Whereas it is alleged in Kodaput vigilance case number so and so, that's a Manoj Kumar Pradhan, ACSO, Malkangiri district so and so, ex marketing inspector so and so, Kalandi, being a public servant, has committed criminal misconduct by misappropriation of 91.11 quintal rice, amounting to 1,44,000 from the RCC Kusumkhunti by preparing and using false and fabricated records during the Kharif session so and so. And whereas the said acts of Manoj Kumar Pradhan, ex so and so, constitute an offence punishable under section 13(2) read with so and so of the IPC. As such, on written report of Sri Jagannath Naik, ex-DCP Vigilance Vanipatna, the aforesaid vigilance case was registered and investigated into. And whereas it is ascertained that Sri Pradhan has reported cent% delivery of the CMR by all the millers by 1/6/2008 by his statement of 4th of June 2008, showing progressive delivery of the paddy and CMR receipt from the customs mills. But in register, it has been reported that he has returned the receipt CMR back to the millers to the extent of 9,000 quintals during July 2008 to July 2000, 16 July to 20th July for improvement. Normally, CMR is received in a depot only after the thorough quality check of the lot. Further, when the stock is received, the same becomes a part of the stock of the OSCSC Limited. In the instant case, this recording of the return of stock seems to be an afterthought, and the same has been handwritten over the computerized report. And whereas this said act on the part of Pradhan constituted an offence under so and so, and whereas I, Madhusudan Padi, Commissioner so and so, being the authority competent to remove the said Pradhan, after carefully examining the case record and having threadbare discussion with the IO, Sri so and so in the regard to the said vigilance allegation, circumstances of so and so has committed an offence so and so. Now, therefore, I so and so, my lord, do hereby accord sanction.
So this is with relation to
Kusum Khunti, my lord.
Kusum Khunti.
And the entire judgment, my lord, with regard to Ladugaon.
Nali pencil. Where from you got that it is the judgment was relates to?
Yes, Lordship may kindly come to that portion where, my lord, the charge was altered. My lord, page 39.
Of the judgment.
Yes.
Yes.
Well, let me start from paragraph 6, my lord, at page 38. Before going to the merits of the case, I would like to deal with some technical points raised during the course of argument with reference to the decisions of the Honorable Supreme Court and the High Court cited by the learned advocate for the parties. I have carefully perused the same for appreciation of the evidence and determination of the points settled. The learned advocate for the accused number 1 submitted that the allegations against the said accused led to irregularities in the strict observations of the guidelines for which criminal action should not have been taken. In this regard, this portion is skipping over. Lordship, kindly come to me next 39. Now 10th line from the top. In the charge, what you got it, Millard?
Yes.
In the charge, the period of tenure of service of the accused number 1 as purchase officer for Koksara and dealt from 8/6/2007 to 4/11/2008 and dealt with the accused number 2 and 3 and the offense of bungling of rice was allegedly committed during the said period. The first date of commission of the offense and the date of act of constituting the offense is not clear. However, their contract period is so and so, therefore I do not find any defect in the framing of the charge against 2 and 2. It is submitted by the learned advocate for the accused person that charge was altered on 13th July 2022. There's some mistake, but the same was not read over and explained to the accused persons, which is a violation of section 216 subsection 2 of the CRPC. And according to him, the section 216 of the CRPC authorizes the court to alter or add to any charge at any time before the judgment is pronounced, and every such alteration shall be read and explained to the accused. In the present case, the charge against the accused persons were framed on 31st October 2017. The accused number 1 was charged under 5 heads under section such as section 30 so and so, and accused number 2 and 3 were charged under 4 heads under section so and so. In the charge, there is a clear mention about the misappropriation of so and so quintal of rice. The cost of the same was noted as 1,44,747, which I read out to your lordship from the sanction. This is Kusum Khunti. The words and figures of the amount of misappropriation was changed to 1 crore 44 lakhs. The said correction was made on the basis of the prayer of the special PP, who pointed out that there was an arithmetical error. While passing the order of correction on 13th of July, the court took into account the admitted price of the rice at so and so per quintal. The amount of rice and the price of the same is also mentioned in the charge sheet. The correction in the charge was mere rectification of a defect in arithmetical calculation and nothing more. Then, but the entire finding is based upon that.
No. You said that it is relates to
only Kusum. Lordship has seen the sanction exhibit 50.
Sanction is Kusum Khunti, but this misappropriation for which you are convicted, it was
for Ladugaon, my lord. For Ladugaon, my lord.
Where from I will get it?
My lord, exhibit 18, my lordship kindly sees, based upon which, my lord, that document your lordship was looking to, exhibit 18, my lord. Your lordship will see at the top, it is RRC Ladugaon.
Exhibit 18 down.
देखिए सर लिखिए देते सर्टिफिकेट को lordship will see at the top it is RRC Ladugaon.
What about the other document, 38?
38 doesn't. It's only DPC Koksara Millard. Under Koksara, these two are there. And your lordship will see kindly Exhibit B, Millard. Exhibit B that has been exhibited through the IO. Lordship may kindly see. Lordship sees, Millard, this Exhibit B.
Exhibit 38 जो এটা जोटा मार्क ହେଇଛି
Again.
ଏଠି ଲେଖା ହେଇଛି ଯେ
Lodugar. Lordship saying?
Statement showing progressive delivery of paddy and CM rice received from custom wheeler as 28/8/2008
Under
DPC
Koksara. Koksara and DPC under Dita, Lodugar and Kusum.
sanction दिया ହେଇଛି कुसुम कुंट्रे.
Again.
But
entire finding Lodugar. And Kusum Kuntra, Lordship kindly see again in the sanction order. The quantity of the rice said to have been misappropriated, or it is 91 point some odd quintals. What is the really?
yes.
But this Lodugar is Malad 9,081.71. It is in the at page 40 of the judgment itself.
Judgment award kala. कितने नंबर पेज खोजेंगे?
Page 40 Malad. Internal page 11.
Cool line.
Malad. 7th line Malad.
ଆପଣ ଏ ଯୋଉଟା ଇଏ ହେଇଛି ଏଟା ଲଡୁ ଗାଁ ପାଇଁ କନଭିକ୍ସନ ହେଇଛି ବୋଲି ମାନେ ସେଟା କୋଉଠୁ
এই quantity Malad এই quantity ରୁ ମୁଁ draw করছি Malad. এই entire quantity হচ্ছে লডুগার কারণ जो दिया है जो sanction होची that is for Kusum Khutti 91 point some odd and the amount will be Malad 1,44. This 1,44,00,000 that is for 9,081.71 quintals of rice and multiplied with the bill of price that comes to 1,44,00,000.
Exhibit 18 টা ଦେଖୁଛନ୍ତି 18 ଟା ଦେଲ.
Okay. লডুগার
All right. Any other submission?
Malad, yes, with regard to that, Malad, I have cited judgments, Malad. And my lord, then coming to my lord, paragraph 13.
13 of your
written notes of submission, page 12.
written note of submission. Page 12, no?
Yes, my lord.
Yes.
Well, the case was instituted on the allegation that the accused petitioner did not keep the rice stock and has not taken steps for inspection. He had made some correction in the computerized statement by writing relevant date as 8th of August in place of 1st of June. Besides, he was booked to have committed conspiracy along with other two accused persons who were the millers. Accused number 1 was supplied with so-and-so paddy and has returned so-and-so custom size mill, which is 68%. Accused number 3 was supplied. No, this should be accused number 2, Malad, not 1. I'm so sorry, Malad.
Correction कर दियो original जहाँ सब भूल
I think what is that? Will the accused number 2 house?
ना से रोड़ा exhibit टा कौन भी भूल देखो उतले से तो बड़ा से रोड़ा
30, your lordship is correct, Malad. 31 is type is a 38 hour. The accused, then accused number 3 was supplied with 29,500 quintals of paddy and returned 20,060 quintals of CMR, which is also 68%. And 5382.33 of substandard CMR was returned to the accused number 2 for improvement. And 5937.36 quintals of CMR was returned to accused number 3 for improvement, which was supplied by the defaulter miller earlier, as per the order of the collector Kalahandi, from out of which the accused number 3 has returned 280 quintals of CMR after improvement. Besides, at the behest of the petitioner, criminal case were instituted against the accused number 2 and 3, and also recovery cases under the OPTR Act. Please refer to exhibit LM and F. But unfortunately, the learned trial court at para 10, page 45 of the brief, did not take this aspect in true perspective to hold that these facts are after the matter was taken up by the vigilance and therefore irrelevant for determination at the point of charge. Besides, they have been given to Malad to better the rice. Then something is returned, something they could not return. So case was filed against them, Malad. Criminal cases are pending. These aspects, when were exhibited, the learned trial court said, no, those things cannot be gone into because they are after the charge was framed. Besides exhibit E, why the exhibit E? It can be seen that two other accused persons who have been acquitted have admitted regarding misappropriation of the CMR. Therefore, when the accused 2 and 3 who have admitted to have committed the misappropriation, when got acquitted for the very same misappropriation, the petitioner could not have been held guilty. Therefore, the order of submission cannot be sustained.
Okay.
Then other aspects.
I may submit a few lines only. In paragraph 4, my learned senior has referred to the decision which was passed by your lordship. That was in a deferred contest. That was charge was not framed regarding 11/7/2006 he was demanding this. That was the exceptional case which is not applicable to the present case. Next, your lordship may kindly refer to the judgment page 57.
Judgment, upon your judgment ଦେଇଥିଲେ
No, judgment court trial court.
Trial court 57
page running page 57, internal 28. Last para. But the above proved, my learned senior has read all these things. But the above proved conduct and positive act of forgery, falsification of accounts, subsequent interpolation of documents by the accused number 1 makes him liable for the offence under section 468, 477 A IPC. So far as the charge under section 409 of the IPC is concerned, admittedly, the accused number 1 being the purchasing officer, he is responsible for the collection of CMR from the concerned millers and to keep proper accounts of the same. It is the own admission of the accused that the accused number 2 and 3 having received 29,500 and 29,800 quintals of paddy respectively for milling, they returned the resultant CMR at the rate 68% of the paddy, that is 20,060 and 20,260 quintals respectively. He has also specifically reported the civil supplies department that there was 100% receipt
of rice from all the millers, including the accused number 2 and 3. It is his specific plea in defense that he returned 5,382.33 quintals and 5,937.36 quintals of CMR to the accused number 2 and 3 respectively for improvement and to return the same. But they returned only small amount of the same and there was due of a little more than 9,000 quintals from them. As already discussed, such fact has not been established by any positive evidence. Such fact of return is within the personal knowledge of accused number 1. And therefore, the burden of proving such fact was upon him as per section 106 of the Evidence Act. The accused number 1 has not discharged this said burden either by examining himself and proving documents or by examining any other person having means of knowledge of such fact. He only relied upon his own created documents which have already been disbelieved. Therefore, it can safely be said that the accused number 1 is solely responsible for causing loss to the government to the tune of rupees 1 crore 44 lakhs 34,621. That is the cost of 9,085.75 quintals of CMR at the rate of rupees 1,588 per quintal. He being the custodian of the CMR and having domain over that property in the facts and circumstances is proved to have committed criminal breach of trust and as such liable for punishment under section 409 of the IPC. The charge under the said head is established against accused number 1 but fails against the accused number 2 and 3. Coming to the charge under section 13(2) of the PC Act, I find the prosecution has established the charge under section 409, 468, 477 of the IPC against the accused number 1, who is a public servant entrusted to deal with the paddy and CMR on behalf of the Civil Supplies Department of the government. It has already been established that he is responsible for the loss of government to an amount of rupees 1 crore 44 lakhs 34,621. At this juncture, another incriminating circumstance which is showing the improper conduct of the accused number 1, which relates to the non-compliance of specific guidelines of the Civil Supplies Department of the government, may also be highlighted. The documents filed by accused number 1 include the agreement of the year 2007 executed by the accused number 3 with the district manager OSCSC Limited Kolandi. As per this document, the duration of the contract was from November 2007 to April 2008. Some important paragraphs of clause 9 of the agreement are reproduced thereunder for appreciation of the facts. The clause agreement of the clause have been quoted. The aforesaid highlighted and underlined portion of the relevant clauses of the agreement makes it clear that at the time of receipt of CMR, the purchase officer has to verify the standards and specifications of the rice and he shall not accept the substandard rice. He is also obliged to briefly record the reason for his such opinion regarding the standard. The agreement also stipulates that after delivery of the rice by the miller shall be deemed to have been completed when the CMR is handed over at the corporation's designed godowns. In the present case, the accused number 1 has neither made any analysis of the CMR returned by the millers nor ever recorded any reason for non-acceptance of the rice from the millers. Rather, he has admitted to have received the rice from millers, accused number 2 and 3, in the godowns of the concerned DPC, and therefore there was no further responsibility of the millers. As per the approved guidelines, the purchasing officer is required to keep samples in case of receipt of any substandard quality of rice, but he has not kept any sample. The evidence of the IO in this regard is that the purchase officer is responsible to ensure the quality of paddy purchased rice as per the quality norms and uniform specification communicated by the government. The accused number 1, on his own admission, is blameworthy. According to the register maintained by him by Exhibit 18, he returned the CMR to the accused persons in between 16/7/2008 to 20/7/2008. The evidence of the IO goes to show that the mill of accused number 3 delivered 20,264 quintals of custom milled rice CMR in between 11/12/2007 to 14/5/2008. The return of CMR by accused number 1, if admitted, shows that there was delay of at least 2 months in the matter for which there is no explanation from the accused number 1. Besides, when contract period was over by the end of April 2008, it is not understood as to under what authority or basis the purchase officer would return CMR on the alleged ground of substandard quality. Why should the millers receive the rice after long lapse of such period? Therefore, examined from all angles, the accused number 1 is proved to be the sole culprit of the entire episode. It is as clear as the crystal that the accused number 1 has not followed the guidelines of the government in proper manner in absence of proof of any bona fide action of the accused number 1 to prevent the loss of such huge amount, and in view of which positive acts of the manipulation of records as discussed above, I am constrained to hold that the accused number 1, by abusing his official position, misappropriated the aforesaid amount by legal manner. The charge under section 13(2) read with section 13(1) CD PC Act is accordingly held well established by the prosecution. The exhibit 18 and 19 has been proved by my lord PW 13. PW 13 has proved exhibit 18 and 19. Page PW 13 page number 2 may kindly be referred. Middle. Exhibit 18 is the rice stock register of Loduga. Exhibit 19 is the custom milled rice issue register of Loduga of 2007-8. Exhibit 20 is the rice register dictating DPC Koksara, Loduga, Godam. So both DPC Koksara and Loduga, it has been proved the registers of both the areas, both the Koksara and DPC Koksara and Loduga. So far as sanction is concerned, my lord, PW 20 has proved the sanction order. Your lordship may kindly refer to page 55. PW 20, paragraph 12.
Yes.
PW 20, paragraph 12. 12. On 27/14, I attended a pre-sanction discussion before Madhusudan Padi, IAS Commissioner cum Secretary Food and Supply Department, Government of Odisha, and I produced copy of FIR and all relevant documents which were seized by me. He perused the same and discussed in detail with me regarding evidence against accused Mr. Manoj Kumar Pradhan, Marketing Inspector Koksara. After being fully satisfied, he accorded sanction which was sent through SP Vigilance Koraput. This is the forwarding letter of SP Vigilance Koraput regarding sanction marked Exhibit 49. This is the sanction order marked Exhibit 50. And on 15/1/2015, I examined the sanctioning authority. So regarding sanction, my lord, if at all any sanctioning authority has accorded sanction against the misappropriation conducted by the accused for the entire, my lord, 1,44 lakhs, some odd, my lord, from both Koksara and Loduga, my lord, 1,44 lakhs and some odd, my lord.
But the sanction order reflects only RCC Kusum Khunti. That is his submission.
He produced all the documents before the sanctioning authority, my lord. He produced all the documents as per the evidence, my lord, paragraph 20.
It's all right, but taking into account the misappropriation of rice from RRC Kusum Khunti to the amount of rupees 1,44 lakhs and
34,621. Right. So it is both, my lord. It is from both DPC Koksara and Loduga, my lord. Your lordship will find from the beginning.
DPC Koksara. But under the DPC, Loduga and Kusum Khunti. So it is a sanction for Kusum Khunti, not Loduga. And that is also explained in para 29 of that PW 20 ballot in the cross-examination. Well, PW 20 in cross-examination, para 29 explains that.
PW?
Same, 20 ballot, the sanctioning authority ballot. Sorry, the IO.
PW 20.
Yes.
So, paragraph?
Para 29. It is a fact that the sanction order Exhibit 50 does not specifically mention about the RRC Loduga. The witness volunteers that it relates to DPC Koksara.
volunteers that
there is no dispute, my lord. Under the
three RSC are coming, including Ladua.
Under the DPC Koksara,
Clarified.
one is Kusum Khunti, other is Laduga. Kusum Khunti granted, Laduga not granted.
It includes my lord.
I would in second explain in the sanction order exhibit 50, your lordship will find there is clear, if there is any doubt, my lord, with regard to what my learned friend says, that doubt, my lord, gets totally demolished in the sanction order. The sanction order says misconduct by misappropriation of 91.11 quintals of rice. But the entire finding with regard to 9,000 some odd, 9,085. That's no preponderance.
Okay.
And also in para 17 of PW20, your lordship will find the PW20, your lordship looking at para 17. The RCC in question, in question is located at Ladugaon and not Kusum Khanti. Millers Jaya Hanuman Mill and Suraj Swanso to RRC, Ladugaon and Kusum Khanti. The total misappropriated quantity is 9,085.75. But that is not the sanction.
That's all.
My decisions may kindly be reported to the lords.
All right, hard Mr. Sergio Sundardas, learning senior advocate appearing for the appellant. Mr. Sanjay Kumar Das, learning standing counsel for the Vigilance Department. It is in that IA. What is that IA number?
IA number
1193 of 2022. Order is approved.
Blood.
Yeah. आइएটা হেডিং দেবে ঠিক আছে না হ্যাঁ এটা আসছে আজ লিস্ট থেকে সেই 119 yes
Item number 3.
Items 3 and 4 also, my lords. They
3 and
relate
4.
to.
It arises out of same case.
No, they arise out of two separate cases. The question is whether your lordship will suspend the conviction or.
Yes. No, last order, it appears that you submitted that you will prepare a note of submission and
prepared a date chart, my lord.
And give it to Mr. Das. So that has been handed over.
My lord.
Yes. Yeah. Yes.
Now the appellant before your lordship, my lords. He is a clerk in the Tahsil office, my lords, who was entangled in a vigilance case.
This is a trap case.
Yes.
Yes.
And he has been convicted there. Now, your lordship admitted the appeal, and during the pendency of this IA for being heard, the appellant has been dismissed from service on 20th of January 2023.
Okay.
Now, if your lordship will look at the impugned judgment, my lords, I'll ask your lordship to kindly look at paragraph 7 of the judgment.
Paragraph 7. Okay. Yes.
The court writes, in the present case, there is no dispute that in the year 2015, accused para 7, page 17, running page 17 of the internal page. In the present case, there is no dispute that in the year 2015, Ghanashyam was working as a clerk in the office of the Tahsildar Junagadh. Star witness of the prosecution, Kulamani Meher, complainant, examined as PW5, deposed in this court that on 10/9/15, he lodged a complaint in the office of the DSP Vigilance, Bhavani Patna unit. Complaint in his handwriting, which was treated as FIR, has been marked Exhibit 12, and he proved his signature as Exhibit 12/4. In the FIR, complainant has specifically alleged that on 23/8/15 and 10/9/15, accused clerk asked for payment of rupees 500 for the purpose of sending Tahsildar's order of demarcation to the RI. In court, he deposed that since Rameswar Nag, not named in the FIR, and Govinda Meher quarreled with him, claiming possession over his land under Khata such and such at Mauja so and so, he lodged a report at Junagadh PS. He also deposed that the police officer handed over a requisition for demarcation of the land, addressing Tahsildar Junagadh, who informed him that due to shortage of staff, demarcation cannot be taken at once and will take some time. He also deposed that some days thereafter, he again went to Junagadh Tahsil office, and the Tahsildar informed him to meet the accused. During course of hearing, prosecution through PW6 proved the case record in demarcation case 234 of 15 as Exhibit 17. This record contains a letter of request dated 22/8/15 made by the IIC Junagadh PS to the Tahsildar Junagadh for demarcation of land with reference to PS SD entry dated 18/8/15. A record also contains application of complainant for demarcation of 4 plots under Khata 88 Mauja so and so. On this application, there are some endorsements said to be made by the Tahsildar with signature dated 23/8/15, wherein it is directed that the RI at his free time can take up measurement of plot 351 only. It is well established from the above mentioned facts that complainant made a grievance at Junagadh PS alleging forcible possession of land by others. The IIC Junagadh, by letter dated 22/8/15, requested Tahsildar to cause demarcation of land of the complainant. Application of complainant in proper form was received by Tahsildar on 23/8/2015. Tahsildar endorsed on the application that the RI concerned shall make measurement of land wide plot number 351. Learned advocate for accused contended that no demarcation case was registered by the date of lodging of FIR, that is 10/9/15, and therefore it cannot be said there was any work pending with accused, and as such there is no question of his making any demand for money as bribe from the complainant. Special PP contends that the accused, with the sole intention to collect bribe from the complainant, kept the application of demarcation with him without sending it to the concerned RI. Admittedly, prosecution has not examined concerned Tahsildar Junagadh or any staff of his office to prove that the application for demarcation was handed over to accused and that he was entrusted to send the same to the concerned RI. Evidence of PW6 reveals that on 11/9/15, he asked the accused to produce demarcation case records and concerned register, which he complied. Case record containing application of complainant, letter of the IIC Junagadh, and demarcation case record of 2015 with entry of the case number 234 dated 11/9/15 was seized in presence of witnesses under the seizure list Exhibit 8. Accused has not denied the fact of seizure of the case record Exhibit 17 and register Exhibit 16 from his possession. He, being the concerned clerk, maintains the register and processes applications for demarcation in discharge of his official duty entrusted to him. It is not his positive plea that application of complainant with endorsement of Tahsildar dated 23/8/15 was kept by Tahsildar himself or someone else. On perusal of Exhibit 17, I find order sheet of the demarcation case in a printed form has not been filled up. Only date of order as 11/9/15, name and address of the applicant are written. Space meant for description of land to be demarcated, name of the RIOMIN, amount to be deposited by applicant, etc. are all blank. Therefore, it's crystal clear that accused though received letter of the IIC Junagadh PS dated 22/8/15 and application of the complainant with endorsement of Tahsildar directing the RI to take measurement of the land of complainant, he sat over the matter for a long time, and only when complainant assured him to pay rupees 500 on 11/9/2015, he started registering the case.
Yes, what is your submission on this?
My lords, my submission on this is that this finding, my lords, is rehearse the earlier observation, my lords, which shows that the Tahsildar on 23/8/2015 has endorsed that the RI at his free time can take up measurement of only one plot. The second aspect, my lords, will see is in the next paragraph what it has been dealt with. Your lordship may see page 20, my lords. The court writes, PWs 1 and 3 have deposed that in their presence.
Which page?
Page 20, my lords. PWs 1 and 3 have deposed that in their presence, complainant disclosed about the conversation between complainant and the accused and amount of demand of rupees 500 by accused. In court, PW5 deposed that accused informed him that he has to pay a sum of rupees 500 as arrear rent, and besides he has to meet some other expenses. There is nothing on record to suggest that complainant was in arrear of rent, land revenue, or that payment of arrear rent was essential for making demarcation of any land. It may be mentioned here that as complainant gave different evidence in court, contradicting the version in FIR and statements recorded under 161 and 164 CRPC regarding prior demand, learned special PP with permission of court put some leading questions to him, and he deposed that the accused told him that if he pays a sum of rupees 500, demarcation will be carried out. It is well settled that prosecution is not bound to prove the particular words or expression of demand of bribe made by the accused. Conversation between complainant and the accused and conduct of the latter as aforesaid, in my considered opinion, amounts to demand of bribe prior to lodging of the FIR. This finding, my lords, is improper. Then at para 8, what the court writes, Your Lordship may see. He says, learned advocate of the accused submitted that complainant wanted to initiate case against the Tahsildar Junagadh and filed a report, but the original FIR has been suppressed and replaced by Exhibit 12. According to him, vigilance have managed to foist a false case against accused. In this regard, he draws attention of court to the evidence of complainant, who stated during cross-examination that he met the Tahsildar on 2 occasions, and on his suggestion, he met accused only on the date of lodging of the complaint. On careful scrutiny of the cross-examination of PW5, I find that he has deposed that when he went to Tahsil office with the police requisition, he met Tahsildar Junagadh, who told him to come after some days. Thereafter, when he went to the Tahsil office for the second time and met the Tahsildar, he told him that only 5 plots can be demarcated. And after some days, when he again went to the Tahsil office, Tahsildar informed that only 1 plot would be demarcated. As a matter of fact, Exhibit 17 reveals that Tahsildar, by endorsement dated 23/8/15, directed for demarcation of 1 plot. Complainant deposed that he visited the office of the Tahsildar Junagadh again and again in connection with demarcation of his plots. And one day the Tahsildar suggested him to meet accused Ghanashyam. He doesn't say that the demand of bribe was ever made by Tahsildar or by accused on behalf of Tahsildar. During cross-examination, he has specifically stated that he met accused on the very day of lodging of complaint, which is in clear contradiction to his earlier version. Complainant, as per information supplied by him at the time of recording deposition, was a labor supervisor and he himself has scribed FIR. If at all he had any grievance against the Tahsildar, he would have narrated the said fact in the complaint. Although he gave prevaricating statement in court, contradicting some part of his FIR, he has not alleged that the FIR was written by him under instruction of anyone else. It reveals from record that on 29/15, he gave his statement Exhibit 15 before a judicial officer. While being examined by the learned judicial magistrate, complainant made allegation of demand of bribe by accused while he met him in the matter of demarcation of his land. But while deposing in this court, he has stated that he met Tahsildar only in connection with his demarcation case. It appears that for some oblique motive, complainant gives a different version about his interaction with the accused in the matter of processing of his demarcation case. Learned advocate for the accused unnecessarily drags the Tahsildar without any evidence against him. Whatever may be, it is well elicited from Exhibit 12 FIR and evidence of complainant that his land in Mauja Brahmaniguda was to be demarcated. In that context, he met the accused who was working as a clerk in the said office. Complainant has deposed that the accused Ghanashyam asked him to pay.
Mr. Panda, I have uploaded. So, what are your main points?
Lords, my submission is that this reasoning which the court is adopting to hold that the appellant before your lordship, milords, is liable for having demanded a bribe, this is not in accordance with the this appreciation of evidence is not proper, milords. Is it for the court to hold, milords, that merely because some statements have been attributed, previous statements have been attributed?
No, complainant is examined as PW
5.
PW 5. In the examination in chief, what he has stated about a demand aspect. First, let us see that.
Your lordship may see at paragraph 2.
Yes.
He says, I have landed property in Mauja Brahmaniguda under Thata 40 consisting of 11 plots. Rameswar Nag and Govinda Meher quarreled with me claiming possession over my land. Thereafter, I lodged a report at Junagadh PS. In connection with that quarrel, police officer handed over a requisition for demarcation to me addressing Tahsildar Junagadh. I handed over the said requisition to the Tahsildar, who informed me that due to shortage of staff, demarcation cannot be taken at once and it will take some time. After some day, when I again went to Junagadh Tahsil, Tahsildar informed to meet the accused present in the dock. When I met accused Ghanashyam, he informed that I have to pay a sum of rupees 500.
This man was the clerk in that Junagadh, that Tahsil office.
Yes.
Yes.
And he also informed that I have also to meet some other expenditure.
Okay.
Thereafter, I lodged complaint in the vigilance office. Vigilance staff informed me to come to the office on the following day, arranging rupees 500 at 8:30 a.m. Accordingly, I visited office of the vigilance Bhavanipatna on the following day.
So, this part of demand,
yes,
he has stated in the chief examination that he said that he informed me. That means you,
yes,
the appellant, that he has to pay sum of rupees 500
as
area rent and
some other expenses.
Okay.
And
then
the FIR was lodged on 10/9/50. Then your lordship may look at paragraph 4. At paragraph 4, he says like this. Your lordship may see the fifth line of paragraph 4. While Patnaik Babu remained in the ground floor, I went to the first floor, met the accused in his chamber, and handing over the 5 numbers of 100 rupee notes, requested him to demarcate all my 11 numbers of plots. Having signal from Patnaik Babu, the vigilance staff arrived there, and when accused dipped his hands in the solution provided by the vigilance team, the color changed to pink. So, at that stage, my lords, when he is talking about the handing over of the bride, there is no demand at all.
No, but you have accepted that what he says.
Yes.
That once somebody is voluntarily accepting it,
my lords,
in view of that constitution bench decision, it presupposes that there was a demand. Otherwise, that is the they say that
I bowed down, my lords. What is the demand? The demand, as per his evidence in paragraph 2, is that 500 towards area rent and to meet some other expenditure.
Right. Yeah.
Is it a demand for bride? Can it be construed to be a demand for bride?
No. If it is a legal one, then matter is different. But question is that when there has there is no demarcation, the land is not recorded anything in his name. So that is why he is coming that I have got 11 numbers of plots.
Exactly, my lords. If he says that he has 11 numbers of plots, if he says that he had a quarrel, and he says that a request was made by the police for demarcation to the Tahsildar, which he had handed over to the Tahsildar, who has said that due to shortage of staff, it cannot be done at once and it will take some time. And he is asked to meet the accused, who is telling him that he has to pay a sum of 500 towards area rent and some other expenditure.
And
Milords,
he has been declared, of course, hostile, and the suggestion which has been given by public prosecutor, he has denied that. It's not a fact that the accused was demanding a sum of as bribe.
Right.
Okay, it's a fact that, then previous statements were confronted under 161 CRPC and have stated that he has denied. Okay.
Your lordship may say, I am placing those.
What? No, what about in the cross-examination, what you have made out here? In that cross-examination, paragraph 6, it starts.
Yes, my lords. He says, it is a fact that I had no prior acquaintance with accused Ghanasya. When I went to Junagadh Tahsil office with the police requisition, I had met only Tahsildar Junagadh on that day, who told me to come after some days. Thereafter, when I went to Junagadh Tahsil for the second time and met the Tahsildar, he told that only 5 plots can be demarcated. After some days, when I again went to the Tahsil office, Tahsildar informed that only 1 plot would be demarcated. I visited the office of the Tahsildar Junagadh again and again in connection with demarcation of my plots. And one day Tahsildar Junagadh suggested me to meet accused Ghanashyam. It is a fact that I met Ghanashyam on the very day of lodging of my complaint. 10/9 ଆଜ୍ଞା FIR ହେଇଛି. ସେଇ ଦିନ ସେ ଆଡମିଟ କରୁଛି କ୍ରସ୍ ଏକ୍ସାମିନେସନ ରେ ଟୁ ହ୍ୟାଭ୍ ମେଟ୍ ମି.
FIR କଣ ଲେଖା ହେଇଛି?
FIR ରେ FIR ରେ ଲେଖା ହେଲା ଲେଖି ଜଣାଇବାର ଅଭିପ୍ରାୟ ଏଇକି ଯେ ମୁଁ ସୋ ଆଣ୍ଡ ସୋ ମୋର ଅମୁକଙ୍କ ନାମରେ ଥିବା ଜମି ମୋ ନାମରେ ଏତେ ଏକର ଏତେ ଡେସିମିଲ ଜମି ଅଛି. ଉକ୍ତ ଜମିରୁ ସେ ରେଲିଭେଣ୍ଟ ପାର୍ଟଟା ମୁଁ ସେ କହିଲା
ଗତ 18/8/2015 ସେଠି ପଢନ୍ତୁ
ହଁ,
ମଝିରେ।
ତାରିଖ 18/8/15 ଅନୁସାରେ ତହସିଲଦାର ଜୁନାଗଡଙ୍କୁ ସେହି ଜମିର ଡିମାର୍କେସନ କରିବାକୁ ଚିଠି ମାଧ୍ୟମରେ ଅନୁରୋଧ କରିଥିଲେ। ଏଟା ପୁଲିସ ବାଲା କରେ। ଜୁନାଗଡ ତହସିଲଦାର କୁଲିହାରି ଆରଆଇଙ୍କୁ ଡିମାର୍କେସନ କରିବା ପାଇଁ ଆଦେଶ ପତ୍ର ଦେଲେ। ଉକ୍ତ ଫାଇଲକୁ ଜୁନାଗଡ ତହସିଲ ଅଫିସର କିରାନୀ ଘନଶ୍ୟାମ ମେହେର ରଖିଛନ୍ତି। ମୁଁ ଗତ 23/8/15 ତାରିଖ ଦିନ ଜୁନାଗଡ ତହସିଲ ଅଫିସ କିରାନୀ ଘନଶ୍ୟାମ ମେହେରଙ୍କୁ ସାକ୍ଷାତ କଲି। ଉକ୍ତ ଡିମାର୍କେସନ ଅର୍ଡରକୁ କୁଲିହାଟ ଆରଆଇଙ୍କ ପାଖକୁ ପଠାଇବାକୁ ଅନୁରୋଧ କଲି। କିନ୍ତୁ ପରିତାପର ବିଷୟ ଏମନ୍ତ କି ଯେ ଘନଶ୍ୟାମ ବାବୁ ଏଇ କାମ ସଙ୍ଗେ ସଙ୍ଗେ ହେବ ନାହିଁ। 8 ରୁ 10 ଦିନ ଲାଗିବ। ଏହା ସଙ୍ଗେ ଖର୍ଚ୍ଚ ବାର୍ଚ୍ଚ ଲାଗିବ। ମୁଁ କେତେ ଖର୍ଚ୍ଚ ଲାଗିବ ବୋଲି ପଚାରିବାରୁ ଶ୍ରୀ ଘନଶ୍ୟାମ ବାବୁ 500 ଟଙ୍କା ଲାଗିବ ବୋଲି କହିଲେ। ଏହା ଭିତରେ ମୋର ଦେହ ଖରାପ ହେବାରୁ ଘନଶ୍ୟାମ ବାବୁଙ୍କୁ ସାକ୍ଷାତ କରିପାରିଲି ନାହିଁ। ଆଜି 10/9 ମଧ୍ୟାହ୍ନ 12:50 ସମୟରେ ମୁଁ ପୁଣି ତହସିଲ ଅଫିସକୁ ଯାଇ ଘନଶ୍ୟାମ ବାବୁଙ୍କୁ ଭେଟି ଡିମାର୍କେସନ ଅର୍ଡର ପଠାଇବା ପାଇଁ ଗୁହାରି କଲି। ସେ କହିଲେ ଆସନ୍ତା କାଲି 11ଟା ସମୟରେ 500 ଟଙ୍କା ଧରି ଆସ। ତା ପରଦିନ ଡିମାର୍କେସନ ଅର୍ଡରକୁ କୁଲିହାରି ଆରଆଇ ପାଖକୁ ପଠେଇବା। ଏ କଥା ଆଜ୍ଞା ଯୋଉ ଜିନିଷଟା ଏଇଟା ଏଫଆଇଆର ରେ କହିଲା ଏଇଟା ତ ଆଜ୍ଞା ଦିସ୍ ହାଜ ନଟ୍ ବିନ୍ ପୁଟ୍ ଟୁ ହିମ୍ ଇନ୍ ହିଜ leading questions which are put, my lord. Once these have not been put, my lords, can it be said that the FIR story has been established? And now here in cross-examination, what he says? He has stated at paragraph 6 that he has met me only on the date the complaint was lodged. And he says that he had met the
that means that was lodged on 10/9/2015.
ତାପରେ ସେଠି ଫେର ଆଡମିସନ କଣ କରିଛି ଆଜ୍ଞା ଦେଖନ୍ତୁ paragraph 6 ରେ in the middle portion my lords will see when he says admits it's a fact that I have lodged the complaint on 9/9/15 that I have lodged exhibit 12 at the instance of DSP Vigilance Bhavani Patna on 11/9/15. It is a fact that accused Ghanoshyam has not demanded any bribe from me on 11/9/15. It is a fact that there was outstanding of land revenue against me for the financial year 13-14 and 14-15.
No, date of lodging FIR होची 10/9/2015 रे।
आई 11/9
नहीं
10/9 रे से गला
10/9 रे ही FIR दिया ହେଇଛି 10/9 ରେ ହିଁ ତାକୁ ପଠା ହେଇଛି ତାକୁ।
ହଁ ଆଜ୍ଞା 10
ସୋ ଯଦି ସେଇଆ ହେଲା ତା ଏଭିଡେନ୍ସ ଅନୁଯାୟୀ 10/9 ରେ ସେ ଫାର୍ଷ୍ଟ ଟାଇମ ମିଟ୍ କଲା
accused.
Okay. As per evidence of PW5, he met the appellant on 10/9/2015 for the first time. Also, so if he met the accused for the first time on 10/9/2015, then this particular lines which he has mentioned that on 23/8/2015 he had met the accused and he demanded that rupees 500. According to you, it is not acceptable.
No.
FIR ରେ କହୁଛି ଯେ ମୁଁ ଗତ 23/8/2015 ରେ ଜୁନାଗଡ଼ ତହସିଲ ଅଫିସ ରେ appellant को meet कली एवं से विषय रे अनुरोध कली किंतु सीए कहिले जे 8-10 दिन लागियो हम खर्च बार्च लागियो खर्च बार्च केते कथा पचारलु कहले 500 टा माने फास्ट डिमांड टा हेची 23/8/2015 आज पर एफआईआर whereas in the from the evidence it appears that on 23/8 he has never met the accused. He met the accused for the first time on the date of lodging of the complaint, which is obviously on 10/9/2015. Right.
The second aspect, my lords, is that the substantive evidence in court of PW5 is that he had to pay 500 as arrear rents and some other expenditure.
अच्छा, you come to the see page 5 रे the evidence of PW5 last 5-6 line खंडे पढ़िला उतरे. It is a fact that on the alleged date of occurrence,
That is 11/9/15. I taking out 5 numbers of 100 rupee currency notes from the paper with which it was wrapped and handed over the accused, and on his denial, I kept those in his left pocket of Sambalpuri shirt. It is a fact that holding both the hands of the accused with my hands, I requested him to demarcate some more plots of my land instead of one. It is a fact that the accused expressed his inability to demarcate more plots than one as ordered by the Tahsildar. It is a fact that I have given my 164 statement in duress. It is a fact that I have given my statement at the instance of vigilance officials. I have been examined by the vigilance police. It is not a fact that I have not stated before the vigilance police that Ghanashyam was demanding rupees 500 towards bribe, but I have stated that rupees 500.
Okay, so this is the nature of evidence which PW5 has given. What about that overhearing witness?
Overhearing witness ala
PW?
Patnaik babu. PW1.
ये कौन कहला?
PW1 कहले पैराग्राफ
पढ़ी जाम तो पूरा सीधा पढ़ी जाम तो ऑफिस को ये जो थी
पैरा 4 पैरा 4 कहला from the 4th line I am placing. Thereafter, I, along with the complainant, went to the Tahsil office at Junagadh, situated at a distance of 1 kilometer approximately, arrived at about 11 a.m. Thereafter, complainant went to the room of the above junior clerk, Ghanashyam Meher, by climbing the staircase of the Tahsil, and I followed him. And thereafter, the complainant met the above Ghanashyam in his office. They talked with each other while I was standing at a distance. Then I saw that complainant paid the above bribe money of rupees 500, consisting of 5 numbers of 100 rupee notes, to the above Ghanashyam, who received the same in his right hand, counted it with his both hands, kept it in his left side shirt pocket. After the transaction was over, I immediately came outside and started scratching my head in order to give signal to the vigilance staff, who arrived in the Tahsil office immediately, identified themselves before Ghanashyam, and asked him as to whether he had received the bribe money or not. And Ghanashyam did not give any definite reply at that time. But to have received the bribe money of rupees 500. Yes.
Anything that means he supported the prosecution
Yes.
case. Anything you have brought out in the cross
Yes,
examination?
your lordship may look at the cross examination.
Only that part we saw
My
that
lord.
about this acceptance part is stated
My
by
lord.
this, yes, because he has not heard what was their actual conversation.
Yes,
That means the demand part is also missing at
My
that
lord.
point of time.
Para 9, my lords may see.
Para 9, yes.
He says, I had also stated in the court that the vigilance authorities had instructed me to give signal to them by scratching my head after payment of bribe money. DSP Vigilance had given requisition to our office for my deputation. It is not a fact that I had stated in court that Vigilance DSP had given letter to me to attend their office on 11, and accordingly I went to the office of Vigilance on the above date. I had not heard the conversation which took place in between complainant and the accused at the time of payment of bribe money.
So that demand part is not there.
Yes.
But acceptance he has stated.
Yes.
Acceptance has stated, and keeping the money in the shirt pocket that he has stated. So again, Mr. Panda, if that bench decision, 5 judge bench decision is taken into account, let us say complainant has not supported the prosecution case fully, but this overhearing witness has seen at least this part that you voluntarily accepted 500 rupees kept, which was recovered from you, and your hand was so and so. So that decision says that once you accept it voluntarily, it presupposes that there was a demand. You must have gone through that decision.
Yes.
So what is your submission
But
to that?
my submission is that here the specific evidence of PW5 in the evidence in chief is that money was asked for payment of area rents and for some other expenditure. This is admitted by him also in his cross-examination. He has admitted this PW5 in cross-examination that there were arrears for the previous 2 years outstanding. সেটা আছে প্রায় এটা প্যারাগ্রাফ
PW5
হ্যাঁ PW5 para 6 রে para 6 ରେ କହିଲା I'm telling you. Your lordship may see 13 lines from the bottom. The sentence begins, it is a fact that. It is a fact that there was outstanding of land revenue against me for the financial year 13-14 and 14-15. ତା ପୂର୍ବରୁ ଆଜ୍ଞା ସେଣ୍ଟେନ୍ସଟା ହଉଛି it is a fact that accused Ghanashyam has not demanded any bribe from me on 11-9-15.
All right. Yes, Mr. Das, ଧର ଟଙ୍କାଟା ବି ସେ ନେଇଛି ଯଦି ହେଲା, କିନ୍ତୁ ସେ ଟଙ୍କାଟା ଯଦି ଆପଣଙ୍କର ବ୍ରାଇବ୍ ନୁହେଁ ଲ୍ୟାଣ୍ଡ ରେଭିନ୍ୟୁ ପାଇଁ ଆକ୍ସେପ୍ଟ କରିଛି, ଯୋଉଟା କି ଆପଣଙ୍କ ସାକ୍ଷୀ କହୁଛନ୍ତି କି PW5 ତ କହିଲା ଡିକ୍ଲାର ହେଲା ହୋଷ୍ଟାଇଲ, ବଟ୍ ସେଇଆ ହିଁ ସେ ଷ୍ଟିକ୍ କରୁଛି। ଆଉ ଆର ସାକ୍ଷୀଟା କନଭରସେସନ କଣ ଶୁଣିନି, କେବଳ ଆକ୍ସେପ୍ଟାନ୍ସଟା ଦେଖିଛି। ତେଣୁ ଆକ୍ସେପ୍ଟାନ୍ସଟେ ହେଲେ ବି ଇଟ୍ ପ୍ରିସପୋଜେସ୍ ଦି ଡିମାଣ୍ଡ ବୋଲି ସେ ଯୋଉ 5 ଜଜ୍ ବେଞ୍ଚ ଡିସିସନ କହିଲା। ହଁ, ବଟ୍ କ୍ୱେଶ୍ଚିନ୍ ଇଜ ଏଠି ଆପଣଙ୍କର ସାକ୍ଷୀ କହୁଛି ସେ ଯୋଉ ଡିମାଣ୍ଡଟା ଯୋଉଟା ବା ହଉଛି ସେଇଟା ଆକ୍ଚୁଆଲି ବ୍ରାଇବ୍ ନୁହେଁ, କାରଣ PW5 ର ଏଭିଡେନ୍ସ ମଧ୍ୟ ଆପଣ କ୍ଲିୟର ହେଲା ଯେ ଇଟ୍ ଇଜ ଏ ଫ୍ୟାକ୍ଟ ଦ୍ୟାଟ୍ it is not a fact that accused demanding a sum of rupees 500 as bribe, जोटा paragraph 5 रो प्रथम line of the cross examination by the special public prosecutor after he was declared hostile under 154 of the Evidence Act. The very first answer he has given to the public prosecutor is that it was a bribe टंका नुहे। ताले से टंकाटा कोन ना से टंकाटा से कहूची जे मोर 2013-14 ଆଉ 14-15 ପାଇଁ ଲ୍ୟାଣ୍ଡ ରେଭିନ୍ୟୁ ବାକି ଥିଲା, ଏରିୟର ଥିଲା, ଏବଂ ସେଇଥିପାଇଁ ଆକ୍ୟୁଜ୍ଡ କଣ କହିଲା ତାକୁ ଯୋଉ ଦିନ ସିଏ ଇଏ କହିଲା ଯେ ଯଦି ଆପଣ 500 ଟଙ୍କା ଏରିୟର ରେଣ୍ଟ ବାବଦ ଦେଲେ ଯାଇକିନି ଆପଣଙ୍କର ଡିମାର୍କେସନ ହବ। ଯଦି ଏଇଆ ଆପଣ ଏଭିଡେନ୍ସ ଆସୁଛନ୍ତି ତାହେଲେ 500 ଟଙ୍କାଟା ଯଦି ବି ସିଏ ଘଟଣା ଦିନ ଗ୍ରହଣ କରିଥାଏ ସେ ଟଙ୍କାଟାକୁ କୁହାଯିବ କି ଏଇଟା ବ୍ରାଇବ୍ ମନି ଡିମାଣ୍ଡ କରିକିନି ଆକ୍ସେପ୍ଟ କଲା ନା ଏରିୟର ରେଣ୍ଟ ବାବଦ ଗ୍ରହଣ କଲା?
I am referring.
Yes.
Your Lordship may kindly refer to the PW5's evidence
Yes.
after the examination declared hostile.
Yeah.
Next sentence, paragraph 5, next page.
Next page.
Yes. But he told me that if you pay the sum of rupees 500, the demarcation will be carried out. Thereafter, 5 lines thereafter, it is a fact that I had lost the complaint in the vigilance office Bhavanipatna due to my harassment for non-demarcation of my land. I had made twice to accuse Honorable Mayor prior to my lodging of the FIR. And both the times he has told me that a sum of rupees 500 would be necessary to meet the expenditure. What is this? What expenditure? What this expenditure was? Where he has stated that land. It is a fact that after the accused dipped his both hands in the solution which changed into pink.
সেটার কিছু ডিসপিউট নাই।
No, I am referring, your Lordship queried, I am referring to his evidence, and also I am referring to the judgment itself. Your Lordship may kindly have a glance to page, running page, internal page 8. Judgment internal page 8.
Judgment. ଦେଖିଲେ judgment କୁହନ୍ତୁ।
6th line. There is nothing on record to suggest that the complainant was in arrear of rent, land revenue, or that payment of arrear rent was essential for making demarcation of any land.
No, ଏଇଟା କୋଉଠୁ ପାଇଲେ?
ତାଙ୍କ ରେକର୍ଡଟା ସିଜ୍ ହେଇଛି। ତାର ଯୋଉ demarcation of the land that has been seized and it has been proved by the IO.
What is that document ଯୋଉଟା ଆପଣ କହୁଛନ୍ତି?
IO's evidence that there was no revenue.
Just ଟିକେ IO କେତେ ନମ୍ବର ସାକି?
6
ଫାଷ୍ଟ ଦିଟା କୁହନ୍ତୁ। ଗୋଟେ ହଉଛି ସେ ଯୋଉ document land register etc that has been seized.
Yes.
And what is the document and which line it indicates that there is I verified it and found that there is no rent outstanding against the complainant PW5.
Your Lordship may kindly have a glance to the evidence of PW6 paragraph 6.
Paragraph 6, okay. ପଢନ୍ତୁ।
I asked the accused to produce the demarcation land identification case record and the Concord register, which he produced. I seized the tenant currency notes under seizure list exhibit 6, the bottle containing so and so, third bucket, copy of seizure list. This is the seized demarcation case register.
କୋଉଟା ପଢୁଛନ୍ତି?
After exhibit 10/3.
ପଢି ଯାଉଛନ୍ତି ନା 4-5 ଲାଇନ ସ୍କିପ କରିକି। Exhibit 16 ହେଲା ହଉଛି ତାହେଲେ ରେଜିଷ୍ଟରଟା ଓକେ। Exhibit 16 what?
This is the land identification rate can record byte number 234 of 2015 marked exhibit 17. So your Lordship, your Lordship can find out this exhibit 16 and exhibit 17, which the complainant also said, and also the
ଆପଣ କହିଲେ ପରା IO further କହିଲା ମାନେ ଯେ ଏଠୁ ଡିମାର୍କେସନ ଇଏରୁ ଜଣା ପଡୁନି ଯେ କୋଉଠି ତାର ବା ଲ୍ୟାଣ୍ଡ ରେଜିଷ୍ଟରରୁ ଜଣା ପଡୁନି ଆଉଟଷ୍ଟାଣ୍ଡିଂ ଥିଲା ବୋଲି ସେ ଲାଇନଟା କୋଉଠି କହିଲା?
ନା ସେଇଟା କୋର୍ଟ ଡିସ୍କସନ କରିଛନ୍ତି ରେକର୍ଡରୁ, ଲ୍ୟାଣ୍ଡ ରେକର୍ଡରୁ। ଲ୍ୟାଣ୍ଡ ରେକର୍ଡରୁ ତାର ରେଭିନ୍ୟୁ କିଛି ନ।
ଲ୍ୟାଣ୍ଡ ରେକର୍ଡ ତ ଦୁଇଟି, ଗୋଟେ ହଉଛି 16 ଆଉ ଗୋଟେ 17। ଆପଣ ସାମ୍ନାରେ 16-17 ଅଛି, ଆପଣ ଦେଖେଇବେ ଯେ ତା ଦେହରୁ କୋଉଠୁ ଜଣା ପଡୁଛି ଯେ ସେ 16-17 Mr. Panda, have you verified those two documents?
16-17 they relate to a register and to the demarcation case. ସେଥିପାଇଁ କେବେ ଦେଖେଇବନି ସେଗୁଡା।
ନାଇଁ ଏଗୁଡାକ ସେ କୋଉଠୁ ଫାଇଣ୍ଡିଂ ଆସିଲା ଯୋଉ ଯେ ତାର ଦେଖଉନି କୌଣସି ବାକି ମାନେ 500 ଟଙ୍କା ବାକି ଥିଲା ବୋଲି ଏରିୟର।
ସେଥିପାଇଁ କେମିତି ଦେଖେଇବ ଗୋଟେ ରେଜିଷ୍ଟର?
କୋଉ ବେସିସ ରେ ସେ କେମିତି ଫାଇଣ୍ଡିଂ କଲା?
That finding of the court, my lords, itself is without any basis.
16-17ଟା କଣ ଟିକେ ବାହାର କରି ଦେଖିବା ଏକ୍ସିବିଟ୍ ଟା, ଲିଷ୍ଟ ଅଫ ଏକ୍ସିବିଟ୍ସ। 15 15ଟା 164 ଛାଡି ଦିଅ ତାପରେ 16 ହଁ ଏଇଟା ତ ଖାଲି ରେଜିଷ୍ଟର ହେଇଛି ଇଏ ଆଧିରେ କଣ ହଁ ଏଇଟା ଯୋଉ ପଟ୍ଟାଟା ଅଛି ପଟ୍ଟାଟା କୁଳମଣି ମେହେର ନାଁରେ ଅଛି ତାର ଖଞ୍ଜଣା ହଉଛି ଫିକ୍ସ ଅଫ୍ ହେଇଛି ଯେ ସମୁଦାୟ ହଉଛି 170.35 ବର୍ଷକୁ ଫ୍ରଣ୍ଟ ପେଜରେ ଲେଖା ହେଇଛି ଏବଂ ଧାର୍ଯ୍ୟ ଅଛି ଓକେ
The complainant is the best person, my lord, to say.
କମ୍ପ୍ଲେନାଣ୍ଟ କହୁଛି ପରା ମୋର ବାକି ଥିଲା ବୋଲି
ବାକି ନଥିଲା ସେ ବା
କୋଉଠୁ
ଖର୍ଚ୍ଚ ପାଇଁ ଦିଅନ୍ତୁ
ଆଚ୍ଛା କଥା ସିଏ ତ କହୁଛି ମୋର ବାକି ଥିଲା ଆପଣ ସିଏ ପରା ଆପଣଙ୍କୁ ସ୍ପେସିଫିକାଲି କହୁଛି ଯେ ବାକି ଥିଲା ଆପଣ କୋଉଠୁ ଜାଣିବେ ବାକି ନଥିଲା ବୋଲି ଅର୍ଥାତ ଆପଣ ପ୍ରମାଣ କରିଥାନ୍ତେ ଯୋଉ ରସିଦ ଦିଆଯାଏ ସେ ରସିଦ ବହି ଯୋଉଥିରେ ଖଞ୍ଜଣା କଲେକ୍ସନ ହୁଏ ସେଥିରୁ ଆପଣ ଯଦି ପ୍ରମାଣ କରେଇଥାନ୍ତେ ଯେ ଅପ୍ ଟୁ ସେ ଯୋଉ ଇୟର ଅଫ ଯୋଉ ଡିମାଣ୍ଡ ପର୍ଯ୍ୟନ୍ତ ତାର ସବୁ ଜିନିଷ କ୍ଲିୟର ଅର୍ଥାତ ସିଏ ପେମେଣ୍ଟଟା କରିଛି ତାହେଲେ ଆପଣ ସେଥିରୁ କହିବେ ଯେ ନାଇଁ ହଁ ଏ ଲୋକଟା ତ ପେମେଣ୍ଟ କରିଛି ଆଉ ବାକି ଥିଲା ବୋଲି ସିଏ ସିନା ମୌଖିକ କହୁଛି କିନ୍ତୁ ଇନଫ୍ୟାକ୍ଟ ବାକି ନଥିଲା ଇଏ ପୋଷ୍ଟାଇଲ ହେଲା ପରେ ତାକୁ ସୁହାଇଲା ଭଳିଆ କଥା କହୁଛି
generally cross examination of he has stated so that he was demanding 500 as kharcha varcha not land revenue, my lord.
Please come
your lordship have gone through the same kharcha varcha. Your lordship
please come to that line
paragraph 6 ଟାକୁ ଦେଖନ୍ତୁ
Mr. page number 5 ରେ paragraph 6 ରେ
paragraph 6 last 6th line, it is a fact bottom towards bottom ram 2 3 4 5 6 7 it is a fact that on the your lordship had correctly pointed out on the day of occurrence 11/9/15 I taking out 5 numbers of 100 rupee currency notes from the paper with which it was wrapped and handed over to the accused and on his dealer had kept those left pocket of Sambalpur sat. I requested him to demarcate some more plots of my land instead of one. Where he has stated that for land revenue, I have handed over those 500 rupees.
My learned friend has marked that with a pencil. He is not reading those deliberately.
No. I am submitting. So let me finish my. So your lordship may kindly have a glance to the judgment. It has been elaborately discussed. Your lordship may kindly have a glance to. I am only referring to a short paragraph 10 of the judgment. Your lordship may, if your lordship permits me, then I will read.
ଶୁଣନ୍ତୁ ଆଉ ଥରେ ଟିକେ ଇଏ କରନ୍ତୁ ସାକ୍ଷୀ ହଉଛି ଆପଣଙ୍କ ସାକ୍ଷୀକୁ ଆପଣ ଡାକିଲେ ଆପଣଙ୍କ ସାକ୍ଷୀ ଆସି ଡକରେ ଛିଡା ହେଲା ସତ୍ୟପାଠ କଲା ପରେ ସିଏ ନିଜେ କହୁଛି ଯେ ମତେ ଆଜ୍ଞା ସେ କିଛି ଲାଞ୍ଚ ମାଗି ନାହାନ୍ତି ମୋର 2013-14 ଆଉ 14-15 ପାଇଁ ଲ୍ୟାଣ୍ଡ ରେଭିନ୍ୟୁ ବାକି ଥିଲା ସେଇ ଲ୍ୟାଣ୍ଡ ରେଭିନ୍ୟୁ ଥିଲା 500 ଟଙ୍କା ସେଇ 500 ଟଙ୍କା ନଦେଲେ ଡିମାର୍କେସନ ହେଇପାରିବନି ବୋଲି ମତେ କହିଥିଲେ ହେଲା ଆପଣ ସ୍ପେସିଫିକ ସଜେସନ ଦେଲେ ନାଇଁ ସେ ଲାଞ୍ଚ ମାଗୁଥିଲେ ସେ ସେଟାକୁ ଡିନାଏ କଲା ବର୍ତ୍ତମାନ ସିଏ ଆସିକିନି କହୁଛି ଯେ ସେ ଟଙ୍କା ମଧ୍ୟ ସିଏ ମତେ ଯେତେବେଳେ ମୁଁ ଦେଲି ତାଙ୍କୁ now you read these lines I took out 5 numbers of currency notes from the paper and handed over to the accused ସିଏ ମନା କଲା on his denial I kept it ମାନେ ସିଏ ନିଜେ ନେଇକିନି ତାକୁ ତା ପକେଟରେ ରଖିଲା ହେଲା
if it would have been a land revenue why he would have put it in his pocket it would have been paid and received
ଓ ସିଏ ଗ୍ରହଣ କରୁନି ତାଙ୍କ ଆପଣ ଓହୋ କେସ୍ ଟାକୁ ଆପଣ ପ୍ରମାଣ କରିବେ ନା
my submission is before your lordship that if land revenue I am going to Tahsil office I will pay my land revenue, my lord. I will pay my land revenue. I will not go again and again to a clerk to pay the land revenue, number one. Number two, he has categorically stated that he had run to the Tahsil office for demarcation of his land on several occasions, my lord. My second point. Third point is, in chief, he has stated to some extent of the demand by this present accused, my lord. And the discussion has been made by the learned trial court at paragraph 10 of the judgment. Your lordship may kindly have a glance to internal page 11. If your lordship permits me, then I will read to some extent. Only paragraph 10.
10 of the judgment କଥା କହୁଛି। ହଁ ପଢନ୍ତୁ କୋଉଠି ପଢିବା।
Coming to the fact of detection, I find the PW6 reports that as per his instruction, the complainant and PW1 proceeded into the Tahsil office Junagadh, whereas they positioned themselves at convenient place near the Tahsil office. The complainant deposed that he and Patnaik Babu went to the Junagadh Tahsil office. Patnaik Babu remained in the ground floor. He went to the first floor and made the accused in his chamber. PW1 deposed that he and the complainant went to the Tahsil office Junagadh at 11 a.m. The complainant went to the room of the clerk Ghanshyam Mer by climbing the staircase and he followed him. PW1 has further deposed that the complainant met Ghanshyam Mer in his office and they talked with each other while he was standing at a distance. He claims that he saw the complainant paid the bribe money of rupees 500 to Ghanshyam Mer, who received the same in his right hand, counted it with his both hands and kept it in his left side.
ଏଇଠି ଗୋଟେ ପଜ ଦିଅନ୍ତୁ। ଆପଣଙ୍କର ଦିଟା ସାକ୍ଷୀ, ଗୋଟେ ସାକ୍ଷୀ କହିଲା ଯେ ମୁଁ କଣ ଦେଖିଲି ନା ମୁଁ ଦେଖିଲି ଇଏ ତାଙ୍କ ପାଖକୁ ଗଲା, କଣ କଥାବାର୍ତ୍ତା ହେଇଛି ମୁଁ ଶୁଣିନି, କିନ୍ତୁ ଟଙ୍କାଟା ତାଙ୍କୁ ଦେଲା, ଟଙ୍କାଟାକୁ ଆକ୍ୟୁଜ କଣ କଲା, ଧରଲା ପରେ ସିଏ କାଉଣ୍ଟ କଲା ଦି ହାତରେ, ତାପରେ ନିଜ ପକେଟରେ ରଖିଲା। ଏଇଟା ହଉଛି ଆପଣଙ୍କର ଗୋଟେ ସାକ୍ଷୀ ଯିଏ ଛିଡା ହେଇକିନି ଦେଖୁଛି, ଓଭର ହିୟରିଂ। ଯିଏ ପାଖରେ ଥିଲା 5 ନମ୍ବର ସାକ୍ଷୀ, ସିଏ କହୁଛି ମୁଁ ଯେତେବେଳେ ଟଙ୍କାଟା ବାହାର କରି ତାଙ୍କ ହାତରେ ଗେଞ୍ଜିଲି ସିଏ ମନା କଲେ, ମନା କଲା ପରେ ମୁଁ ନିଜେ ତାଙ୍କ ପକେଟରେ ପୁରେଇ ଦେଲି। ଏଇ ଯୋଉ ଦିଟା ସାକ୍ଷୀ ଆପଣ ଦେଲେ ପ୍ରମାଣ କରିବାକୁ, ଏ ଦିଟା ସାକ୍ଷୀଙ୍କର ଷ୍ଟେଟମେଣ୍ଟରେ ତାଳମେଳ ରହୁଛି? ଆପଣ ପରା ଜଣକୁ କନଭିକ୍ସନ କରିଛନ୍ତି ଦିଟା ସାକ୍ଷୀର ଏଭିଡେନ୍ସ ଉପରେ, ରିକଭରି ପାର୍ଟ ଛାଡି ଦିଅନ୍ତୁ। Recovery part.
That your lordship has gone through that 5 judge bench decision in paragraph 2067. That acceptance is proof.
Acceptance, voluntary acceptance would presuppose that there is demand.
Yes.
ଜଣଙ୍କର ଯୋଉ ପକେଟ ରେ ଜବରଦସ୍ତି ଗେଞ୍ଜି ଦବାଟା ଏଟା ଭଲ୍ୟୁଣ୍ଟାରୀ ଆକ୍ସେପ୍ଟାନ୍ସ ଭିତରେ ଯାଏ।
ନାଇଁ, ଜବରଦସ୍ତି ଗେଞ୍ଜି ଦବାଟା ଅନ୍ୟ ସାକ୍ଷୀ ମାନେ କିଏ କହିନାହାନ୍ତି? ଟିଏଲଓ କହିନି, ଟିଏଲଓ ରେଡ୍ କଲେ।
ସେଠି ଟିଏଲଓ କୋଉଟା ଆସିବ ସେଠି ଆଜ୍ଞା?
ଟିଏଲଓ ଯେତେବେଳେ ଇଶାରା ପାଇଲେ ସେମାନେ ରେଡ୍ ହ୍ୟାଣ୍ଡେଡ୍ ଧର।
ଟିଏଲଓ ଆସେ କେତେବେଳେ? ମୁଣ୍ଡ କୁଣ୍ଡେଇଲେ, ପାନିଆରେ ମୁଣ୍ଡ କୁଣ୍ଡେଇଲେ।
ଓଭର ହିୟରିଂ ୱିଟନେସ୍ କହିଲା ଯେ ଦେଲା ପରେ ମୁଁ ଦେଖିଲି, ଦେଲା ବେଳେ ମୁଁ ମୁଣ୍ଡ କୁଣ୍ଡେଇଲି। ୟୁର ଲର୍ଡସିପ୍ ହାଜ୍ ଗନ୍ ଥ୍ରୁ ଦି ଏଭିଡେନ୍ସ ଅଫ PW1। ସେ କହିଲା ଯେ ଦେଲା ପରେ ମୁଁ ଇଶାରା ଦେଲି, ଟିଏଲଓ ହେରିକା ଆସିଲେ। Your lordship has gone through PW1's evidence.
ଟିଏଲଓ ହେରିକା ଖାଲି କହନ୍ତି ରିକଭରି ପାର୍ଟ।
ନାଇଁ, PW1 ଓଭର ହିୟରିଂ as your lordship କହି ସେ କହିଲା ଯେ ଟଙ୍କା ଦେଲା ପରେ ମୁଁ ମୁଣ୍ଡ କୁଣ୍ଡେଇଲାରୁ ମାନେ ବସିଗଲେ। So that part is clear that he has accepted. Why did he accept? My question is, why did he accept? So the most point is, your lordship on the previous occasion has asked my learned friend about only 2 questions. Your lordship may kindly peruse the last.
You leave that. Let us say that by stay of conviction he will not get back his service.
Yes.
किंतु ता मुंडरे इटा जो झुलिकिनी रहिछि वर्तमान जो कन्विक्शन टा हेइछि से स्टे आमे इटा अपील टा को 5 वर्ष परे विचार करियो।
No, they can prepare the paperwork and
नाइ ना सेटा संभव न। आपण सिना कहि दउजनी आपण जो हियरिंग लिस्ट रे जति उठुची सब गुडा ता दिरु पूरा 50-60% ट्रैप केस।
So, the Honorable Supreme Court has made the guideline not to stay a conviction in this type of cases. And again, also the 5 judge bench rendered the decision regarding stay of conviction. And also, I have cited
it does not say that in no case you cannot.
Exactly. Exceptional circumstances. What is the exceptional circumstances?
आपण कोनादी कोनटा एक्सेप्शनल हो?
किछि नाही, exceptional circumstances he has got.
आपण कोंदु जे एक्सेप्शनल सही केस जो थरे दी जण जाको केही सपोर्ट करनथिबे बा तांको भितरे ताळमेळ न रहिले भी एटा गोटे एक्सेप्शनल।
As your lordship has dictated in Sirari Charan Das case, that is one exception. Here there is no exception. So, and also another judgment has been rendered by your lordship in 2018. That is an exceptional.
Actual aspect रे को टाइप रो कोन ऑब्जर्वेशन आसीबो आपण गोटे केस रे नै किन कहबे तार identical facts or ये थिले matter is different.
Your lordship may kindly refer to my subsequent decision which I have referred. I have given the decisions besides the decision earlier cited. I have cited the decision 4 decisions. Even in one case,
आपण ए जो चारटा देइछन दी
ए चारिटा देइछि besides my referring to decisions in my objection paragraph
हाँ गोटे तो
ତା
जो
ବ୍ୟତୀତ
2023 जुलाई पार्ट रो 91 ओसीआर
ସେଇଟା
सेटा
ସେଇଟା
होची
ତାପରେ ଦୁଇରେ
प्रकाश साहनी
ସେଇଟା ଆଉ ଜଣେ ରେଫର କରିଛନ୍ତି ପାଟନା ହାଇକୋର୍ଟ ସେଇ ଡିସିସନ ଟାକୁ 1 ନମ୍ବରକୁ ଆଉ
ଶୁଣନ୍ତୁ ସେଥିରେ ହାଇକୋର୍ଟ ଷ୍ଟେ କରିଥିଲା କନଭିକ୍ସନ ନେଇକିନି କଣ ନା ପଲିଟିକାଲ ରାଇଭାଲରି ଅଛି, ଡିଲେ ଇନ୍ ଲଜିଂ ଅଫ ଦି ଏଫଆଇଆର ଅଛି, ଓଭର ରାଇଟିଂ ହେଇଛି, ଏଫଆଇଆର ହେଇଛି, ଏଇଗୁଡାକ ନେଇକିନି ସେ ଷ୍ଟେ କରିଥିଲା କନଭିକ୍ସନ। ତା ଦେହରେ ଅନବଲ
ମେରିଟ
ସୁପ୍ରିମ
ବି ଯାଇଥିଲେ ମେରିଟରେ ବି ଯାଇଥିଲେ
ଓହୋ ଯାହା ଦେଇଛନ୍ତି ଆପଣ ମୁଁ
ହଁ
ସେଇଥିରୁ
ଲେଖିଛୁ
କହିଲେ
ମେରିଟ
ଅନବଲ ସୁପ୍ରିମ କୋର୍ଟ କହିଲେ ଏସବୁ ଜିନିଷ ସେ ଡିଲେ ଇନ୍ ଲଜିଂ ଏଫଆଇଆର ଓଭର ରାଇଟିଂ ପଲିଟିକାଲ ରାଇଭାଲି ଏଗୁଡାକ ଫାଇନାଲ ହିୟରିଂ ଷ୍ଟେଜରେ ଦେଖାଯିବ ତାକୁ ତେଣୁ ତା ବେସିସ ରେ କନଭିକ୍ସନ ଷ୍ଟେ କରିବାଟା ଉଚିତ ନଥିଲା ହାଇକୋର୍ଟଙ୍କର।
I have also some mentioned the merits of the case, my lord. First, in first instance, the appellate court should not reappreciate the evidence at the stage of 389 CRPC and try to pick up some few lacunas or loopholes here and there in the case of prosecution. Such would be not be a correct approach. Thereafter, this line, my lord. The second one followed the decisions of number 1. Number 3, my lord. Another decision I have cited, my lord, even on merit, even though appellant was dismissed from service, no sympathy was drawn by the Honorable Apex Court for this dismissal of delinquent job. Conviction was upheld, my lord. Number 3. Number 4, your lordship is aware. This 5 judgment decision. My lord. So now, my lord, my submission would be that some special circumstances after dismissal from service and in a bribe case, trap case, my lord, and trap case, all the decisions starting from cases are in and others. This Dattatreya Kumara, Balakrishna Dattatreya Kumara, etc., and also your lordship's judgment itself. This trap case, all these discrepancies regarding whether complainant stated so and the varies through PW1, the overhearing witness and traveling officer, etc. My submission before your lordship that all these factors will be decided at the time of final hearing of the appeal, my lord.
Right. That's all, Mr. Panda. Same order pass कर देंगे जे hard Mr. Devashish Panda, land counsel for the appellant who files the date sheet which is taken on record, and Mr. Sanjay Das, learned standing counsel for the vigilance department. Order is reserved. That is it pass करिवे से जो IA number 2367 of 2022. ଆଉ ଯୋଉ ଦିଟା ଅଛି ସେଟା ଆସନ୍ତା ସପ୍ତାହରେ ନବା
ସେଇ ଟ୍ରାପ୍ କେସ୍
ହଁ ହଉ ହେଲା 4 5 ମିଷ୍ଟର ଆଜି ଦିଟା ଶୁଣି ସାରିଲେଣି ଆସନ୍ତା ମଙ୍ଗଳବାର ଦିନ ଆସନ୍ତା ମଙ୍ଗଳବାର ଦିନ ସପ୍ଲିମେଣ୍ଟାରୀ ଆସିବ ଏ 4 5 ଟାକୁ ମଙ୍ଗଳବାରକୁ ରଖିଦିଅନ୍ତୁ
ରିଟିନ୍ ନୋଟ୍ କିଛି ମାଇନର ସିନିୟର
ମଙ୍ଗଳବାର ହଉଛି 5 ତାରିଖ ହଁ 5 ରେ ଅଛି ମ୍ୟାଟର 5 ରେ କଣ ଅନ୍ୟ ମ୍ୟାଟର ପୋଷ୍ଟିଂ ବୋଲି କହୁଛି 12 ରେ ତାର ଲଗଦ ଅଲରାଇଟ୍ ଦିଟା ଯାକ ମ୍ୟାଟର ରଖିଦିଅନ୍ତୁ ତାହେଲେ 12 9 2023.
Our only apprehension is that they may remove us in the meanwhile, and here it's a strong case. I had appraised before my lord, the complainant is dead, 2 of the major witnesses have been declared hostile, and the trial court has also not reflected on that aspect. One major witness has been ignored. Our notes of submissions have not been taken into account. It's too lopsided, my lord.
12/9/23, all right. On consensus kar debe, both the parties list this matter on the supplementary nature of detail. Yes. Now this weekly list come back to the weekly.
ବାହାରକୁ
ରହିଲା ପରେ 12 ତାରିଖ ରହିଲା ଦିଟା ଯାକ ହଁ ପୂଜା ଯାଇଥିଲା
Weekly list item number 39.
My lord, on behalf of S.K. Mohanty, my lord,
Fresh appeal, my lord. Notice to go, my lord.
SCST appeal.
My lord.
39. All right. এটা নোটিস করে দেবে extra copy by tomorrow, huh?
My lord.
Extra copy CD और C है 40 नंबरটা fresh matter.
Yes, my lord. Fresh matter.
Where is Mr. Rogor? এই দেখিয়ে
That
নো
is
কি
also
40 নম্বর দেখিয়েছো তো ডিসপ্লে বোর্ডে আচ্ছা এটা भी সেমতি
that
fresh
is also
matter
SCST, my lord.
notice extra copy by tomorrow CDCA next
41 your lordship.
fresh matter
Malad, on earlier occasions, the petitioner approached this Honorable Court for bail which was numbered as bail appeal 5270/2019. And the same was rejected by order dated 14/8/2019. And after the commitment of the case, the petitioner was preferring this present bail application. And the petitioners are prosecuted under section 45307, 302 and 34, read it 120B of the Indian Penal Code.
Just a minute.
My lord, here in this case, should we kindly see that earlier it was rejected by my lord Justice Pujari, my lord. And thereafter also, on the second occasion, it was 14/11/2022, my lord. Dismissed, my lord.
14/11/22.
By my lord Justice G.S. Saput, my lord.
Dismissed for default.
But
same was
whether it took
no. Then it was perhaps it was restored perhaps.
Yes, disposed of, my lord.
No. Thereafter it was restored perhaps. That is why it has come to me. The CRLMA filed prayer for restoration, and accordingly his lordship has restored it. Now,
now, your lordship, another important thing is that your lordship kindly see that the impugned order, bail rejection order, that is of 2018.
What?
After my lord, charge sheet have submission of charge sheet.
And by that time, charge was framed.
Counsel, your last bail application number kete?
5270.
5270, my lord.
5270 or 2000.
No, ये जो bail application टा इटा होची 2020 रो.
2020.
My lord.
तापरे आपण bail आउ move करनांती तଳ court रे?
City case number.
मोर प्रश्नटा सुनंतु. आपण एठी जो बेल टा फाइल करछंती ता धेरे 18/6/2020 रो ऑर्डर टाकू आपण रिजेक्शन ऑर्डर अगेंस्ट आछन. एई पेंडिंग थिला भितरे जदि आपण तळ कोर्ट रे बेल मूव करनथिबे अलगा कथा. जदि करिथिबे आ भितर 3 वर्ष एही गलानी. तनु बेटर यू गो देयर, मूव एन एप्लीकेशन, and if it is rejected you can come again. This bail application was filed after the petitioner's bail application was rejected by the London Trial Court on 18/6/2020. Since in the meantime more than 3 years have already passed, if the case is still sub judice, the petitioner is at liberty to renew the prayer for bail in the trial court. Accordingly, BLAPL is disposed of. Yes.
Item 44.
Please take.
नियम करी कहूची या करी सता कहबी किछि मिछ कहबी नै कि लुचाइबी नै सर मते सहाय
Please take your seat. Well, last question ready. You value typing your it's great. Good. Yes, please continue. कोटा क्वेश्चन देखियो आपने
Exhibit 43 44 अपन लियो तो सेम अच्छे affidavit
Yes.
ଦେଖନ୍ତୁ ଏଇଟା ଆପଣଙ୍କ original affidavit in form 26
को पेज रो पचारियो प्रश्न
my lords may kindly see page 6
Yes.
page 6 है जो column 5 to Roman 2 रो D रे जो लिखिसंती आपण brief description of offenses आपण मेंशन करचंती 1 चार्ज 3 चार्जेस करी केमते ये 1 चार्ज माने गोटाए केस आपण को 426 रे पेंडिंग अछि ना 426 रे चार्ज फ्रेम मिलछि आपण को विरुद्ध
brief description of offenses my lord यदि offense मोर हेतिला ता ऊपरे each offense रो brief description दवा पे कॉलम रे instruction अछि
नहीं इसी प्रश्न होची आपण गोटे जगह लिखचंती 3 चार्जेस गोटे जगह लिखचंती 2 चार्जेस सब ऑफेंस भी लिख देचंती
आगे
ता माने आपण कैलकुलेशन करचंती जे आपण नारे जेति को केस माने 13 टा जो केस रे सेथिरे आमे जदि देखिबा गोटिए मात्र ऑफेंस अछि जोटा होची 426 सेमती तीनटा ऑफेंस अछि जो थरे ऑफेंस लागि छी 427 एई टाइप रो तो
आगे
माय लॉर्ड इतरे मु देई देची नंबर ऑफ ऑफेंसेस की दरकार नथिला खाली ऑफेंस डिस्क्रिप्शन दरकार थिला
नहीं नहीं ठीक अछि माने नहीं आपण जो देइछन ना चारिटा चार्जेस तीनटा चार्जेस ता माने होची या तो
चार्ज माने आपन नारे तीनटा केस दुईटा केस ना चार्ज फ्रेम हेची आपन को से ऑफेंस
केस जोड़ा एफआईआर
केस गुड़ा से
मु
मीन
एफआईआर
कोड
कथा पछने आपन ए जो चार्ज लिखिचंती से चार्ज माने कोन बुझांतो आप
चार्ज माने जो एफआईआर मनारे रजिस्टर्ड हेची
अच्छा
अबाउट 427 आईपीसी सेक्शन
420
47 तार डिस्क्रिप्शन ता
427 रे आपन नारे केस हेची ता डिस्क्रिप्शन आपन लिखिचंती
नेचुरली जोड़ा हमरो
हां सेटा ब्रीफ डिस्क्रिप्शन ऑफ द 427 रो येटा लेक्चर मिसचिफ कॉजिंग डैमेज टू द वन सो 50 रुपीस किंतु ये जो तीनटा चार्ज माने कोन लेक्चर ता माने कोन माने तीनटा केस रे ऑफेंस 427 और 427 ये तो सीएससी पचर अच्छा लिखो इन कॉलम नंबर ये पड़ीला पेंसिल टा इन कॉलम नंबर एटा होची केते
5 रोमन 2
2D
2D
Roman 2D comma where अच्छा ये जो ऑफ से जो एग्जिबिट ऑफ माय एविडेंस ऑफ माय एफिडेविट इन फॉर्म 26
एग्जिबिट 43
दे दो
44 44
एविडेंस इन एफिडेविट माय एफिडेविट इन फॉर्म 26 ब्रैकेट लिख दियन से जो चारटा जो
एग्जिबिट 43 44 45 46
हां से चारटा नहीं आसन छोटो हां comma where I have to give brief description of offense, comma, I have mentioned as to
number of charge
number of charges of a particular offense. Number of charges of a particular offense is pending. A number of charges is pending against me. I mentioned as to ये जगह was कर देंगे was pending against me at the time of filing of nomination paper. अपन पर्सनल चार्ज माने कौन
चार्ज माने केसेस
अच्छा चार्ज मीन्स according to me under which the case has been registered ये पूछ नहीं पचल अपन ये
I have mentioned as to number of charges of particular offense was pending against me at time of filing of nominations
हां अपन से पचल जो चार्ज लिखिले से चार्ज माने कौन अपन को भाषा रे सेटा होची जो थरे केस रजिस्टर्ड हेची जो सेक्शन ने केस रजिस्टर्ड हेची आपण सेया भाबी कि नहीं लिखिले चार्ज बोली
माने एठी मु भाबुतले ब्रीफ डिस्क्रिप्शन ऑफ चार्ज जो ऑफेंसेस
नहीं आपण पूरा लिखि वर्ड यूज करजंती जे वन चार्ज टू चार्ज थ्री चार्जेस फोर चार्जेस एम सब लिखि जंती प्रश्नटा आपण पचारजंती चार्ज आपण जो लिखजंती चार्ज माने कोन आपण कहले जे जहा कहबे वर्तमान भी लिखाई जे चार्ज मींस अंडर व्हिच ऑफेंस द केस हैज बीन रजिस्टर्ड व्हिच केस ने अंडर व्हिच ऑफेंस द केस हैज बीन केस had been registered had been कर case had been registered हला against me कर दियंती अच्छा हां
देखंतु कॉलम 5 रोमन 2 सी रोमन 2
कॉलम 5
पेज 5 पूर्व पेज रे देखो सी रो रोमन 2 देखो रोमन 2 रे आपण लिखिचंती कमीशन ऑफ ऑफेंस अंडर सेक्शन 147 148 342 450 395 हला 395 आपण डिस्क्लोज करछन ए कॉलम डी रे 395 विषय रे कोठी लिखिचंती कोन ଆପଣଙ୍କ କଲମ ଡି ରେ ସେକ୍ସନ 395 ରେ ଆପଣଙ୍କ ନାଁରେ ଯୋଉ କେସ୍ ରେଜିଷ୍ଟର ସେ ବିଷୟରେ ଡିସକ୍ଲୋଜ କରିନାହାନ୍ତି।
ଡିସକ୍ଲୋଜ ହେଇନି। ଯଦିଓ ଏ କଲମଟାରେ ଲେଖିଛନ୍ତି ଆପଣ ଯେ ଗୋଟେ କେସ୍ ଅଛି ଯୋଉଥିରେ 395 ଟା ହଉଛି ଡକାୟତି। ତ ଏମିତି ଗୋଟେ ଅଫେନ୍ସ ଆପଣଙ୍କ ନାଁରେ ପେଣ୍ଡିଂ ଅଛି, କିନ୍ତୁ ଆପଣ ସେଟାକୁ କଲମ ଡି ରେ ଉଲ୍ଲେଖ କରିନାହାନ୍ତି।
ଏଭିଡେନ୍ସ ଏଫିଡେଭିଟ୍ ଦେଖେଇବି ଆଜ୍ଞା, ପଚାରିବି ଆଜ୍ଞା, ଏଇଟାକୁ
ଏଇଟା କହିଦିଅନ୍ତୁ।
ଏଇଟାକୁ କହିସାରନ୍ତୁ ମୁଁ
Sir,
ଏଭିଡେନ୍ସ ଏଫିଡେଭିଟ୍ ଦେଖେଇବି।
395 I think ସେମାନେ ଓମିଟ କରିଦେଇଥିଲେ
କୋଉଥିରେ ଓମିଟ କରିଥିଲେ?
ଫାଇନାଲ ଚାର୍ଜସିଟ୍ ରେ।
ନାଇଁ ଆପଣ ଯେତେବେଳେ ସେ ଚାର୍ଜସିଟ୍ ରେ କଣ ହେଇଥିଲା ଅଲଗା କଥା, ଆପଣ କଲମ ସି ରେ ଲେଖୁଛନ୍ତି ଯେ 395 ର ଗୋଟେ କେସ୍ ଆପଣଙ୍କ ନାଁରେ ପେଣ୍ଡିଂ ଅଛି, ତେଣୁ ଓଭିୟସଲି ସେଠି ତ ଆପଣ ଓମିଟ କରିଦେଇଥାନ୍ତେ ନା ଯେ 395 ଟା ଆପଣ କଟି ଯାଇଥିଲା, ତାହେଲେ ଆପଣ ସି ରୋମାନ 2 ରେ ବି ସେଟାକୁ ଦେଖେଇ ନଥାନ୍ତେ। ତେଣୁ ସେଥିରେ ଦେଖେଇଛନ୍ତି ମାନେ ସେଇଟା ସେତେବେଳେ ସେମିତିଆ ଗୋଟେ ଦଫାର କେସ୍ ଆପଣଙ୍କ ନାଁରେ ପେଣ୍ଡିଂ ଥିଲା ବୋଲି 5C2 ରେ ଦେଖେଇଛନ୍ତି। ଯଦି ସେଠି ଦେଖେଇଛନ୍ତି ତାହେଲେ ତାଙ୍କର ପ୍ରଶ୍ନ ହଉଛି ଏ ବ୍ରିଫ ଡେସ୍କ୍ରିପସନ ଅଫ ଅଫେନ୍ସ ରେ କାହିଁକି ସେଇଟାକୁ ଦେଖେଇଲେ ନାହିଁ, ଏଇଆ ହଉଛି ତାଙ୍କ ପ୍ରଶ୍ନ।
ଆପଣ ସେଇଟା କହିସାରନ୍ତୁ, ମୁଁ ଯିବି ସେଠି।
ମାଇଲଟ କ୍ଲରିକାଲ ଏରର ହେଇଥିବ।
ଆଚ୍ଛା ଲେଖନ୍ତୁ। It is a fact that while describing the sections of Consent Act oblique codes involved in 5 bracket Roman 2C in my affidavit in form 26, comma, in column number Roman 2,
ଏଟାକୁ ସିରିୟଲ ନମ୍ବର କରୁଛି।
in serial number, acha, in serial number Roman 2, comma, I have mentioned one of the offense to be under section 395 of Indian Penal Code, but in column number 5 bracket Roman 2 bracket D, while giving brief description of offense, comma, I have omitted to mention any case of offense under section 395 of Indian Penal Code is pending against me. Stop. The omission in column number 5 to D was a clerical error. Stop. Yes.
ଦେଖନ୍ତୁ,
Under to be pending. Good. To be. Okay. Yes.
ଏଇ ଯୋଉ ଏକ୍ଜିବିଟ 17 17ରେ 395 ରେ ଆପଣଙ୍କ ନାଁରେ କେସ୍ ରେଜିଷ୍ଟର୍ଡ ହେଇଛି ବୋଲିକି ଜଣା ପଡୁଛି।
এটা হচ্ছে পুরীহাট পিএস কেস নম্বর। এটা କୋଉ କେସ୍ ନମ୍ବର? এটা ପୁରୀହାଟ ସିରିୟଲ ନମ୍ବରଟା କେତେ ଥିଲା? ହଁ ସିରିୟଲ ନମ୍ବର 2 ତ ଅଛି। ପୁରୀହାଟ ପିଏସ୍ କେସ୍ ନମ୍ବର 149 ମାନେ ନମ୍ବର 1 ଟା।
ए रे बी रे सॉरी ए रे नंबर 1 टा तार कॉरेस्पोंडिंग जीआर भी 1 बी रे भी 1
हां
सी रे होची सीरियल नंबर 2।
ओहो अच्छा अच्छा এটা 1 রে করিয়া গেছে লেখা। 147 148 342 450 395 332 427 354 294 हाँ ये सब ऑप्शंस अच्छी
395 ता डिस्क्लोज करनो
कोड से डिस्क्लोज
ए जो डी रे लिखि नांती कि
हाँ डी रे तो लिख सेटा तो गलामाणी सेटा गलाणी
ए जो एफआईआर रे जो 395 रे केस रजिस्टर्ड हेची एटा आपण कॉलम 5 रे डिस्क्लोज करिना
C2 रे डिस्क्लोज करिछि पर
मु डी कथा पछत
नहीं
डी रे ऑफेंस लिखा है
सेटा गला पर ओमिटेड टू
रे भी सर से जो एफआईआर रे भी डिस्क्लोजेस
एफआईआर रे पूरा एग्जिबिट रहला कॉलम नंबर 5 2
सेटा
सी टा
अछि
हां
ए एफआईआर रजिस्टर्ड हेची 395 रे that has not been disclosed in column 5T
सी तांकर सी पूरा कहउछन चार्ज माने मुजा बुझिली सेटा होची रजिस्ट्रेशन ऑफ द एफआईआर ऑफेंस तांको भाषा रे वी आर नॉट से
ठीक अछि ताहाले आपण जो कहउचंती एटा क्लरिकल में एरर एटा मिछ कथा कहउचंती वोटर माने को मिसलीड करिया को आपण जानि का को डिलीट कर डिस्क्लोज करिना
मिस्टर इट्स नॉट ए फैक्ट सेम नहीं कॉपी करनी है सुन कौन सा पूरे दरे नहीं ता पूर्व कौन थिला सेटा नहीं बैक कर दियंतो आपसे काटी दियंतो पूरा I have mentioned but so that is तारी पर सेटा लगेबे it's not a fact that omission of offense under section 395 of the Indian Penal Code in column number 5(2)(d) was not a clerical error, and that it was done deliberately to mislead the voters of 90 Baravati Assembly constituency. Stop. Yes.
देखंतु कॉलम 5(2)(c) रो सीरियल नंबर 3 7 8 9 10 13
सीरियल नंबर 3
3 7 8 9 10 13 you have declared commission of offense under section 13(2) read with 13(1)(d) of PCI, but you have not declared about these offenses in column 5(2)(d) of your affidavit.
Which one?
13 to 13(1)(d) ला Roman 3 गुट्टे
Roman 3
then
7
don't ठीक करूं 7 2 next
8 next
8 13 2 31 D, हाँ 3 नंबर 4 नंबर
9
13 2 31 D S 4 नंबर तापरे
10
10 13 2 13 S 5 टा
then 13 XII
XII हाँ एटा 6 तो 6 टा केस आपन ना रे 13 टू रेड सेक्शन 13(1) D PC Act registered ହେଇଛି ବୋଲି ଏଠି ଉଲ୍ଲେଖ କରିଛନ୍ତି କଣ କହୁଛନ୍ତି କୋଉଥିରେ ଉଲ୍ଲେଖ କରିନାହାନ୍ତି
column 5 to D रे
ଓ D ରେ ଜମା
you have
ଟୋଟାଲ ଉଲ୍ଲେଖ
not,
ହେଇନି
you have not disclosed about column 5 to
ठीक है
column 5 to
निश्चित चार्जेस अंडर कंट्रोल अच्छा अच्छा राइटियस मिस्टर मुकिम छटा केस आपन को ना रे आपन देखी छंती 13 13 टू रेड सेक्शन 13(1) D रे और पीसी एक्ट रे अच्छी बेली कॉलम नंबर सी रे सेटा को डी रे छाड़ी दै छंती से कुछ प्रश्न होची सेया
My lord, ये 13(2) and 13(1) से offences against the government officers, public sector जो public office bear करथान এবং these are related to vigilance case and vigilance cases सेठी जो माने विनोद कुमार एक्सेट्रा थिले से तांको पई प्रযোज्य थिला not for private party आमो पई नथिला तो तेनु सेटा को हमें ब्रीफ डिस्कशन ने मेंशन नैनो this case is not against me
সেই কারণ যোগু আপন উল্লেখ কলেনি
उल्लेख
ইয়া করছুନ୍ତି
आगे
all right it's a fact that though I have mentioned the offenses, the cases for commission of offenses. The cases not really 6 cases for them. 6 cases for commission of offenses under section 13(2) read with section 13(1) D of Prevention of Corruption Act are pending in column number 5 to C of my affidavit in form 26 exhibit asiala comma but
in serial number like
in in serial number अच्छा हो ठीक है
serial number
8 serial number लिखि दियन सेटा नहीं सेठी नो सेठी बॉट नहीं अच्छा 8 serial number
that serial number Roman 3 7 Roman 7
ठीक है धीरे धीरे कौन 7 3 पर कॉमा दियंतु 7 कॉमा भी 8 तापरे IX 9 10 गोटा होची 13 एंड लिख दियन हां 13 आउट वर्ड एकटा जोड़ा हो हां 13 but in column number 5 to D हाँ ठीक of the affidavit comma I have omitted to mention such offenses as those offenses are applicable to Mr. Vinod Kumar Vinod Kumar, who is an co-accused in the case, who is a co-accused in the case and a public servant. कौन है
My lord, different cases ହେଇଛି different officers ମାନେ ଅଛନ୍ତି ତା ଦେହରେ involved.
अच्छा विनोद कुमार and other अच्छा विनोद कुमार and other government officials है who are the like them are the co-accused in such cases and they are public servants. They were and they were public servants. हाँ ठीक ଆଉ ଥରେ ପଢିଦବା ମୁଳୁ back କରନ୍ତୁ हाँ ରହିଥିବ ସେଠି it is a fact ନାଇଁ ସେଇ it is a fact ସେଟା ନୁହେଁ ମୁଁ हाँ it's a fact though I have mentioned 6 cases for commission of offences under section 13(2) reduced section 13(1)(d) of the Prevention of Corruption Act are pending in column number 5(2)(c) of my affidavit in form 26 at serial number so and so. But in column number 5(2)(d) of the affidavit, I have omitted to mention such offences as those offences are applicable to Mr. Binod Kumar and other government officials who are the co-accused in such cases and they were public servants. हाँ ठीक है
जदि ये सेक्शन आपन को एप्लीकेबल नथला आपन कॉलम 5(2)(c) रे काहेकि लिखिले सेटा को उल्लेख करले सेठी भी काटी देइथां
My lord जेहेतु एफआईआर रे थिला
अच्छा
एलिगेशन
all right
सो काटी देले
question ठीक है question करूँ if you have omitted to mention the offense under section 13(2) of the Prevention of Corruption. If you have omitted to mention offense under sections 1 of the Prevention of Corruption to be pending in column number 5(2)(d) of your affidavit in form 26 so and so hala why সেটা কাটি দেন পুরা আচ্ছা হ্যাঁ সেটা নিয়ে আসুন why then you mentioned those offenses in column 5(2)(c hala at serial number so and so hala set কাট দেন লাস্ট কাট দেন question mark করুন answer লিখুন as the 6 cases were registered under the offense under section 13(2) so and so এটা কাটি দিন হ্যাঁ পুরা কাটি দিন তারপর কাটি দিন সেটু হ্যাঁ comma I thought it proper to mention the same in column number 5(2)(c) whereas deleting the same in column number 5(2)(d) as those offenses are not applicable to me. Stop. बाकी तो कर दूं. Yes.
ए जो ऑफेंस आपन को एप्लीकेबल के नुहे एटा आपन निजे को निजे डिसाइड करले ना कौन सी कोर्ट होल्ड करचंती ऑफेंस गुरा आपन को एप्लीकेबल नुहे
offense होची not against the private persons.
ମୁଁ ସେ କଥା ପଚାରୁନି, ଏଇଟା ଆପଣ ନିଜକୁ ନିଜେ ଡିସାଇଡ କଲେ ଇଏ ଆପଣଙ୍କ ନାଁରେ ଅଫେନ୍ସ ରେ ଏଫଆଇଆର ରେଜିଷ୍ଟର୍ଡ ହେଇଛି?
Co-accused ବି ଅଛନ୍ତି ତା ଦେହରେ।
ମୁଁ ଆପଣଙ୍କ କଥା ମୁଁ କହୁଛି ଆପଣଙ୍କ ନାଁରେ ଇଏ ଅଫେନ୍ସ ରେ ଏଫଆଇଆର ରେଜିଷ୍ଟର୍ଡ ହେଇଛି କି ନାହିଁ ଆଗେ
Only
କୁହନ୍ତୁ।
for that I mentioned in the
ଆପଣଙ୍କ ନାଁରେ ଇଏ ଅଫେନ୍ସ ରେ ଏଫଆଇଆର ରେଜିଷ୍ଟର୍ଡ ହେଇଛି ନା ନାହିଁ କୁହନ୍ତୁ।
ହେଇଛି।
ହେଇଛି, ତାହେଲେ ଯେହେତୁ ଆପଣଙ୍କ ନାଁରେ ଏଫଆଇଆର ରେଜିଷ୍ଟର୍ଡ ହେଇଛି, ଆପଣ ନିଜେ ଭାବିଲେ ଏଇଟା ଆପଣଙ୍କୁ ଆପ୍ଲିକେବଲ ନୁହେଁ ନା କୌଣସି କୋର୍ଟ ହୋଲ୍ଡ କରିଛନ୍ତି ଏ ଅଫେନ୍ସ ଗୁଡା ଆପଣଙ୍କ ଆପ୍ଲିକେବଲ ନୁହେଁ?
ନାଇଁ ମୋର ଲୟର ୟାକୁ ପ୍ରିପେୟାର କଲେ affidavit ମୋର, ସେତେବେଳକୁ ସେ ତାକୁ delete କରିଛନ୍ତି because this is not applicable to us because I
All
was
right.
not at that time
Question.
a village or
Another
public
question. Okay. Okay. When those 6 cases were registered against you and the co-accused persons who were government servants under the offense, 13 to reduction, 13 to 13. When those 6 cases were registered against you and the co-accused persons who were government servants under so and so, comma, whether you yourself decided that such offenses are not applicable to you, or there was any decision of the court in that respect? Question mark. Answer. My lawyers who verified my affidavit in Form 26 suggested to omit such offenses in offenses କରନ୍ତୁ କାରଣ କେତେଗୁଡ଼ା offense 7 ରହୁଛି ଏ ଯୋଉ 13 1 2 offenses in Form 26 in column number 5(2)D as those were not applicable to me. Suggested to omit such offenses as those were not applicable to me. Okay. Yes.
ଦେଖନ୍ତୁ, ଆପଣଙ୍କ ନାଁରେ ସେକ୍ସନ 13(2) ରେଡ୍ ୱିଥ୍ 13(1)D ରେ ଏଫଆଇଆର ରେଜିଷ୍ଟର୍ଡ ହେଇଛି। ଆପଣ ଜାଣି ଶୁଣିକି ସେ ଅଫେନ୍ସ ଗୁଡାକୁ କଲମ 5(2)D ରେ ଡିକ୍ଲେୟାର କରିନାହାନ୍ତି।
It's not a fact. Not a fact, Mr. Sir. It's not a fact that I have deliberately omitted to mention the offenses under section 1313.
Exhibit B, C, D.
In column number 5(2)D of my affidavit in Form 26. Suggestion is to mislead the voters. Mislead the voters of 90 so and so. Okay. Yes.
ଆପଣଙ୍କ ନାଁରେ ଯୋଉ କ୍ରିମିନାଲ କେସ୍ ପେଣ୍ଡିଂ ଅଛି, ଆପଣ ତାକୁ ନ୍ୟୁଜ ପେପରରେ ପବ୍ଲିଶ କରିଛନ୍ତି। ସେ ପେପର ଆପଣଙ୍କ ଆଡୁ ଦାଖଲ ହେଇଛି, ଏକ୍ଜିବିଟ ହେଇଛି B1, C1 ବୋଧେ D1।
ମୋ ପାଖରେ ଗୋଟେ C1 ଅଛି।
C1 ଆପଣ ଆଉ ଗୋଟେ D1 ଥବ, ଦିଟା ଆପଣଙ୍କ ପାଖରେ ଥବ। ମୁଁ B1 ଧରିଛି।
D1 ଦିଟା ଅଛି ହଁ
ମୁଁ ଗୋଟେ B1 ଧରିଛି।
ହଁ ଠିକ ଅଛି ମୁଁ ପଚାରୁନି
ଠିକ
ନ୍ୟୁଜ ପେପରରେ ଦିଆ
ହଁ
ସେଟା ଦରକାର
ମୁଁ ଆକୁ ଆଜ୍ଞା କୋରିଲେଟ କରୁଛି। ଏଇଠି ଦେଖନ୍ତୁ ଆପଣ ଏ ନ୍ୟୁଜ ପେପରରେ ସିରିଆଲ ନମ୍ବର 7 ସିରିଆଲ ନମ୍ବର 8 ସିରିଆଲ ନମ୍ବର 13 ରେ
ନାଇଁ 9 ବି ଅଛି
9 ର
13 to 30 red with 13 1D ଅଛି
ଆପଣ 13(2) ରେଡ୍ with 13(1D) ଆପଣଙ୍କ ନାଁରେ କେସ୍ ପେଣ୍ଡିଂ ଅଛି ବୋଲି ପବ୍ଲିଶ କରିଛନ୍ତି। ଯଦି ଏଇଟା ଆପଣଙ୍କର ଆପ୍ଲିକେବଲ ନଥିଲା ଆପଣ କାହିଁକି ଏ ନ୍ୟୁଜ ପେପରରେ ପବ୍ଲିଶ କଲେ?
My lord, I have already mentioned because ଆମେ ୟାକୁ FIR ରେ ଦେଇଛୁ FIR entire ଯାହା ଦଫା ଲାଗିଥିଲା ପୁରା ରିଜୁଟ କରାହେଇଛି and this particular is not for a private person. So
ଏଇଟା FIR ଯେହେତୁ ରେଜିଷ୍ଟର୍ଡ ହେଇଥିଲା ସେଇଥିପାଇଁ ପେପର ପବ୍ଲିକେସନ ରେ କରିଛୁ ଆଚ୍ଛା
as per the affidavit
all right put it in a question if the offense offense under 13 hello offense under section 3 was are not applicable to you, then while making declaration about the criminal cases in format C1 C-1 in newspapers bracket like दियंतु exhibit B/1 exhibit C/1 exhibit D/1 ସେଇ ତିନିଟା ତ
ଆଜ୍ଞା ତିନିଟା
D/1 E ନୁହେଁ D for Delhi why did you mention such offenses question mark answer since FIR of those cases were registered under the 13(2) le asanti 13(2) read with section 13 hala as per the advice of my advocates I mentioned the same in exhibit B/1 C/1 and so on hala ei jo tinta yes
ଆପଣ ଯୋଉ କହିଲେ ଆପଣଙ୍କ ସେକ୍ସନ 13(2) ରେଡ୍ with 13(1D) is not applicable ତାହେଲେ ଆପଣ ଏ ପେପରରେ ଫଲ୍ସ ଡିକ୍ଲାରେସନ ଦେଇଛନ୍ତି କି ଆପଣଙ୍କ ବିରୁଦ୍ଧରେ 13(2) ରେଡ୍ with 13(1D) ରେ ପ୍ରିଭେନ୍ସନ ଅଫ କରପ୍ସନ ଆକ୍ଟ ରେ କେସ୍ ପେଣ୍ଡିଂ ଅଛି।
not a fact it's not a fact that I have made false declaration in exhibit B/1 that cases for commission of offenses under section so and so are pending were pending against me stop baki to kaट दियन
ଦେଖନ୍ତୁ କଣ କଲମ 5(2) ର D ରେ ଆପଣ ଲେଖିଛନ୍ତି 3 charges related to mischief causing damage to the amount of 50 rupees IPC section 427 serial 2 ରେ ଅଛି
ଦେଖିସାରିଲେଣି ପ୍ରଶ୍ନ କଣ
whereas in column 5(2)(c), रे आपण serial number column Roman 2, 6, 11, 12 रे declare करिसंती section 427 रे आपण विरुद्ध चारिटा केस
कोटा कहले आउ थरे कोन
2 Roman 2
हां
6
6 रे 427 अछि हां तापर
11
XI 427 अछि आउटा
12 XII
हां चारटा केस पेंडिंग अछि 427 रे तीनटा लग yes what do you say Mr. Mokin
My lord, ये brief description of office रे आवश्यकता नथला हम मेंशन कर देइछु कोडी कम कोडी बेसी कोडी कोन टिके हेतिबो my lord logical mistake
all right 75 it is a fact that while mentioning the offense under 427 in 4 cases
427 IPC लिख दी
427 of Indian Penal Code in 4 cases pending against me comma in column number 5 bracket रे 5 हेमति नेमो 5 bracket रे Roman 2 bracket रे small c हला
serial number
भाइड serial number
Roman 2
करंतु तापरे Roman 6 करंतु
XI
XI करंतु and करंतु XIA it's a fact that while mentioning the though I have mentioned it's a fact that though I have mentioned कर दियंतु the offense under in 4 cases pending against me and so and so but I have mentioned in column number 5(2)(d) that 3 charges under section 427 of Indian Penal Code pending against me. Stop. Against me, stop. It was not required on my part to mention how many charges of a particular offense was pending. Where pending? Where? Pending against me in column number 5(2)(d) and only brief description of offense was required to be mentioned in it. But due to clerical mistake, I have omitted to mention one more charge under section 427 of Indian Penal Code to be pending against me in column number 5 to D. D. Also, Podia Mudur Dekan. It is a fact that though I have mentioned the offense under section 427 of the Indian Penal Code in 4 cases to be pending against me in column number 5 to C, hide serial numbers so and so. But I have mentioned in column number 5 to D that 3 charges of a 3 charges under section 427 were pending against me. See, jaha likhijan sei language mu quote kali. Hala. It was not required on my part to mention how many charges of a particular offense were pending against me in column 5 to D. And only a brief description of the offense was required to be mentioned in, but due to clerical error, I have omitted to mention one more charge under section 427 of the Indian Penal Code to be pending against me in column number 5 to D. Yes. कौन लगी?
Which I have mentioned will which I have mentioned.
Good happened.
Only the description of offenses required to be mentioned in it.
Only free will.
Which I have mentioned. Which I have mentioned.
Which I have mentioned. Which I have mentioned. But due to clerical error, I have omitted to mention. All right. Yes.
ଏଇଟା ତ ଦରକାର ନଥିଲା କିନ୍ତୁ ଆପଣ ଲେଖିଲେ ତା ମାନେ ଆପଣ ଭୁଲ ତଥ୍ୟ ଲେଖିବେ ନା ଠିକ ତଥ୍ୟ ଲେଖିବେ?
Next question. If it was not required at all to mention the number of charges of a particular offense in column number 5 to D, but you have mentioned the same in such column, whether you were required to mention the same correctly or wrongly? Question mark. Answer. যদি দরকার নথিলা টোটাল লিখি নথান্তে 2টা 4 3টা 4 যেহেতু লেখিলে সেটাକୁ যদি ମିଶାମିଶି କରିକି ଲେଖିଲେ ତାହେଲେ ସେଟା ଠିକ ଭାବରେ ଉଲ୍ଲେଖ କରିବାର ଥିଲା ନା ଭୁଲ ଆପଣ ଉଲ୍ଲେଖ କରିବାର ଥିଲା? Advocate କହିବେ. My advocate can only reply about this same. କିଏ ତରଣୀ ବାବୁ କହିବେ ନା ଆଉ କିଏ କହିବେ? ହଉ, next question.
ତାହେଲେ ଆପଣ ଏ ଯୋଉ ଆଫିଡେଭିଟ ଫର୍ମ 26 ରେ ଫାଇଲ ଦାଖଲ କଲେ ଏଇଟା ଆପଣ ନ ପଢିକି ନ ଶୁଣିକି ଆପଣ ଓକିଲ ଯାହା ଲେଖିଲେ ଆପଣ ଦାଖଲ କରିଦେଲେ, ସ୍ୱୟଂ କରିଦେଲେ, ଦାଖଲ କରିଦେଲେ?
No, sir. It's a question. Question darkar. It's not a fact that without properly, you mean to say without properly verifying? Okay, without properly verifying the contents of the affidavit to be true.
Affidavit in form 26.
Affidavit in form 26. In form 26 to be true, I have mechanically signed it. Yeah, तो suggestion. Okay.
Mechanically signed it as prepared by
as prepared by
your advocate.
By your advocate. By my advocate. हाँ. नहीं, it's not by my advocate. हाँ, ठीक है. By. Yes.
ଦେଖନ୍ତୁ ସେମିତି ଆପଣ କ୍ଲଜ 5(2)D ରେ ଲେଖିଛନ୍ତି 2 charges under section 341 IPC, whereas ଆପଣ column 5(2)C ରେ serial number 5, 6 and 12 ରେ ଲେଖିଛନ୍ତି ଆପଣଙ୍କ ବିରୁଦ୍ଧରେ 341 ଦଫାରେ 3ଟା କେସ୍ ପେଣ୍ଡିଂ ଅଛି।
5 ଆଉ ଗୋଟା
5, 6, 12
ଆଉ ଗୋଟେ ହେଲା 12 341 300 5 ରେ ତ ନାହିଁ 341 ହଁ ଅଛି
5, 6, 12
5 6 4 ଦିଅ ହଁ ତିନିଟା ଏଟା କେତେ ଲେଖିଛନ୍ତି ଦିଟା ଲେଖିଛନ୍ତି ଅଛି सेम आंसर हबो कोन लिखि जंतु इट्स एटा कॉपी करी आने आसंतु हां देजन इट्स ए फैक्ट दैट आई हैव मेंशनड द ऑफेंस अंडर सेक्शन 341 of the Indian Penal Code in 2 cases hala to be pending against me in sorry 3 cases to be pending against me in column number 5 to C भाइड सीरियल नंबर हला जा कहउछंती 5 करंतु प्रथमे 6 और 12 XII हला आरटा काटी दियंतु सेटा लास्ट को एंड कर दियंतु but I have mentioned in column number 5 to D that 2 charges under section 341 were pending against me. It was not out सेटा लिखिबे एटा पाव दरकार नै एटी एटा सहित रही जे कवर कर ओनली ब्रीफ नै लास्ट टू हां I have it was not due to clerical lesson सेटा लास्ट टू पढ़े सुनो I have omitted for them I have omitted to mention one more charge under section 341 to be pending against me in column 5 to D on account of clerical error. And same suggestion you will give. से जो टले suggestion जो
it's not a clerical error.
It's not a deliberately done.
It has been deliberately done.
It is not a fact that omitting to mention one more charge under section 341 of the Indian Penal Code was not a clerical error, was not a clerical error, but it was done deliberately to mislead. It was done deliberately to mislead the voters of so and so. Stop the end. It is not a fact that omitting to mention one more charge under section 341 of the Indian Penal Code was not a clerical error, but it was done deliberately to mislead the voters of 90 Baravati Cuttack Assembly constituency. Yes.
ଆପଣ ଆପଣଙ୍କ ଏଭିଡେନ୍ସ ଏଫିଡେଭିଟ୍ ରେ ଲେଖିଛନ୍ତି it is not required to furnish total number of charges made against the candidate under particular
evidence को paragraph को
page 84 area last 6 lines तळाडू sentence begins 84
तांको सामना दिउन से पर देखिबे ना
ଆପଣଙ୍କର
एटा नहीं जानतो
therefore एटा
ओरिजिनल टा नहीं हम पर वो लाइन टा कन्फ्रंट करंतु तापरे
ତଳ ପଟେ ମୁଁ underline କରିଛି 6th line. Therefore, it is not required to furnish total number of charges made against the candidate under particular sections and code in column 5(2)(d). जदि column 5(2)(d) रे दरकार नथला एवं आपण एटाको लेखिले आपणक विरुद्ध रे दीटा चार्ज आपण ठीक केनी लेखिया कथा ना भूल लेखिया कथा मिछ कथा लेखिया कथा
से जाइछि पूरा सही टाइप प्रश्नटा आउ थरे कॉपी करी पेस्ट कर देन कॉपी कर दियंतु हाँ सेटा को हाँ हाँ सेम तो ही जो पर्टिकुलर सेटा तो गला मिस्टर सेम दिन सा कोन रिपीट कर
ऑफेंस रे गला तो
नहीं एका कथा मु सेठी ऑफेंस लेखी नहीं माने खाली पर्टिकुलर आउ दरकार नहीं रिपीट हे जो छाड़ हां नहीं नहीं मु सेटा पर्टिकुलर ऑफेंस कर लिख दी
he has repeatedly in each paragraph he has stated the very same
नहीं नहीं इट्स ऑलराइट इट्स मुझे रे ऑफेंस सेठी उल्लेख करथांदी आउ तरे से क्वेश्चन टा रिफ्रेम करी से ऑफेंस टा को इंसर्ट कराई थान
कोंतु आपण लिखिचंती कॉलम 5(2)(d) रो टू चार्जेस
एटा दे जंतो
अंडर सेक्शन 294 आईपीसी
ओरिजिनल नंबर अछि हां कोटा कोटा कहले
टू चार्जेस अंडर सेक्शन 294 आईपीसी
हां
whereas in column 5(2)(c) रे आपण सीरियल नंबर 1 रोमन 2 4 5 6 12
5 आउट केते
4 5 6
6 टा 294 अछि हां
12
टा भी अछि हां
6 cases under section 294 is pending
2 3 4 5 हां 6 टा केस हला 294 रो 6 टा केस केटा देख के देखि जंदी दीटा देखि जंदी अच्छा और कोई वैसे सेम आंसर मिस्टर clerical error all right it's a fact that though I have mentioned the offense under section 294 of the Indian Penal Code in 6 cases to be pending against me in column number 51C भाइड serial number लिखुन डाकी दम serial number
1
Roman 1
2
Roman 2
4 अछि
IV अछि तापरे 5 अछि
6
अछि कर देला तापरे
and 12
and last and further but I have mentioned in column number 5 and 10 that two charges under section 294 set of the Indian Penal Code are pending against me. I have omitted to mention 4 more charges under section 294 to be pending against me in column number 5 to D on account of clerical error.
एटा आपण जो कहउचंती क्लरिकल एरर नहीं आपण जानी सुनी की जेहेतु भोटर जानी पारिबेनी आपणक विरुद्ध रे 294 दफा रे 6 टा केस पेंडिंग अछि आपण 2 टा केस डिस्क्लोज करछन
It's not a fact that I have deliberately omitted to mention 4 charges. FOUR 4 charges under section 294. 4 charges for the offense under section 294 of the Indian Penal Code. Allah, to be pending against me. सेटा था उसेटा दरकार हो परे से जो कॉलम नंबर 5 to D टा दरकार हो to be pending against me हला in 5 to D of my affidavit informed to mislead the voters of cutters form so that
5(2)(c) रे मेंशन करछि लिखिबा ने
एटा प्रश्न हो 5 to D ऊपर लिखा है अच्छा सॉरी जो देखे दो आउतरे so that the voters would not be in a position to know how many cases under such offense are pending against me. Stop कर दियंतु बैक करी देखिए दियंतु से प्रश्नटा देखंतु आउ थिरला इट इज ए फैक्ट दैट दो आई हैव मेंशनड हला आपण कहले प्रथमे 294 कॉलम नंबर 5 टू सी रे 6टा केस पेंडिंग अछि बोली आपण मेंशन करिसंती कोठी मेंशन करछिन ना एई जगह रे किंतु 5 टू डी रे आपण जेतेबेले मेंशन करछिन दीटा देखैजंती आ 4टा ओमिट कर देइजंती जोटा कि आपण कहउजंती क्लरिकल एरर हला से तांगा सजेशन ता तापर तळु गडे आनसु ता सजेशन ता हला जे नाही मिसलीड करियो को आपण एमती करछंती सो दैट वोटर माने जानी परिबेनी आपनरे केतेटा 294 दफार केतेटा केस पेंडिंग अछि जोटा कि आपण डिनाय करले यस स्टॉप दियन
देखंतु आपण कॉलम 5 2 डी रे 5टा चार्ज आपण को विरुद्ध रे सेक्शन 149 रे पेंडिंग अछि बोली देखिछन whereas in column 5 2 c serial number 1 2 4 5 6 11 12 so 7 cases are pending against you under section 149 IPC.
आउ थर्टी कहले सीरियल नंबर उडागो
1
हां
2
हां
Roman 4
4
5
5
6
6
11
11
and 12
दफाटा कोन
149 IPC
149 से देखे जनी पांचटा अच्छा देखियो 149 अछि 149 अछि 2 149 अछि 149 4 अछि 149 5 अछि 149 अछि तो 149 से 1 2 3 4 5 6 7 हां 7टा केस होची 149 ना देखै जंदी 5टा same answer Mr. Okay. It is a fact that do have mentioned the offense under section 2b in 7 cases to be pending against me in column number 5 to c serial number गुडा को टिके कोन तुम सवाल
serial number
5 रोमन 1 कहले तापर 2 कहले
4
4 अछि 5 अछि 6 अछि
11 12
11 and 12 hala but I have mentioned in column number 5 to D that five charges under section 149 so and so are pending against me. I have omitted to mention 2 more charges under sections to be pending against me on account of clerical error. It's not about that I've deliberately omitted to mention two charges.
194 no 149
under section 149 of the Indian Penal Code to be against so and so due to mislead of yes.
तेम देखंतु आपण कॉलम 5 2 डी रे लिखिचंती 3 चार्जेस अंडर सेक्शन 332 आईपीसी
केतरा अछि
तथर आगे दीटा अछि
कोडा
कॉलम 5 2 सी रे सीरियल 2 and 11
2 and 11 offense कोन कहउजंदी 332 और 49 332 332
कहले
332 बेली गोटे दफा जोटा आपण को नारे एक्चुअली से कहउजंती दीटा केस पेंडिंग अछि जोटा आपण देखैचंती
तीनटा केस पेंडिंग अछि
हां एठी लिखिचंती 332 रो तीनटा केस बेली 5-2 डी रे किंतु प्रकृति रे आपण दीटा गोटे अधिका देखै दैचंती कॉलम नंबर 5 डी रे
ऑफिस नंबर 332 तो
हां 332
5-2 रो 2 रे रोमन 2 रे दिटा गोटे अछि
हां
आ गोटे
अछि 11 नंबर रे से दीटा रे केवल अछि माने दीटा लिखिया कथा 2 चार्जेस आपण लिख दैचंती 3 चार्जेस से पॉइंट आउट करछन आपण अधिका गोटे लिख दैछन कोन ला सी सेंटेंस look, it's a fact that though I have mentioned the offense under section so and so in 2 cases to be pending against me in column number 5 to C. By serial number la gote hochi 2 a gote hochi 11 hala, but I have mentioned in column number so and so that 3 charges hala under section 332 of Indian Penal Code are pending against me. I have it omitted me. I have added one more charge under section 332 of the Indian Penal Code to be pending against me so and so on account of clerical error. It is not a fact that I have deliberately added to mention one more charge for the offense so and so on be pending against me in column number 5 to mislead the voters so that the last to cut them to mislead the voter. Yes.
ଦେଖନ୍ତୁ କ୍ଲଜ 5(2)D ରେ ଆପଣ ଲେଖିଛନ୍ତି 5 ଚାର୍ଜେସ୍ ଅଣ୍ଡର ସେକ୍ସନ 420 IPC।
ଏଇଟା ଅଛି କୋଉଟା କଣ
where is in column 5(2)C रे serial number 3 7
7 VII हाँ तापरे 8 रे भी अछि 420
8 9
9 अछि
10
10
and 13
10 ने अछि हाँ आ गोटे कोटा
13 XII
But
total 6
13
cases under section 420 has been registered against you, but you have falsely declared that 5 cases has been pending against you under section 420 IPC।
छटा हला तो 1 2 3 4 5 6 छटा जक हेले सेटा अपन लिखछन कि एटा 5टा लिखछन है हां सेया लिखि दियन कोन हला I have mentioned offense under so and so in 6 cases to be pending against me column of 5 to C in serial number 3
7 8 9
9
10 and 13
10 and 13 ठीक है but I have mentioned in column number so and so that 5 charges are cases 5 charges under section 420 of the Indian Penal Code I have omitted to mention one more charge under section 420 of the Indian Penal Code to be pending on account of ठीक अछि on account of clerical सेटा कोड 420 हे जो deliberately omitted to mention one more charge for the offense under section 420 of the Indian to be pending against me in so and so in my affidavit to mislead the voters and सेटा था उसे last sentence था it so that the voters would not be in a position to know how many cases under section under such offense are pending against me
सेमती देखंतु आपण क्लॉज 5(2)D रे लिखिचंती 5 चार्जेस अंडर सेक्शन 120B of IPC
5 charges 120B
whereas in column 5(2)C रो serial number 3 7 8 9
धीरे धीरे कौन से उड़ा 3
7
थ्री गोटे तापरे
7
7 120 भी अछि हां तापरे
8
120 भी हां 3
9
9 120 भी अछि 4
10
10 अछि हां
13
13 अछि 120 भी हां केतरा हला
6टा
1 2 3 4 5 6 हां 6टा केटा लिखछन्ती
5टा लिखिछन
5टा लिखछन अच्छा सेम आंसर होगा
से उत्तर सेम हबो खाली 1.420 टा 1.1
हां 120 भी हां मुझे देखी दे one more charge so body use. It's a fact that though I have mentioned the offense under section 420 120B of the Indian in 6 cases to be pending against me in column number 5 to C in serial number 3 7 8 9 10 and 13 but I have mentioned in column number so and so 5 charges under section 120B were pending against me. I have omitted to mention one more charge under section so and so to be pending against me on account of clerical error. It's not a fact that I have deliberately omitted to mention one more charge of the offense so and so to be pending against me of my affidavit to mislead the voters so and so that the voters okay.
ଏମିତି ଦେଖନ୍ତୁ ଆପଣ କଲମ 5(2)D ରେ ସେକ୍ସନ 143 ରେ ଦିଟା ଚାର୍जेस ବୋଲିକି ଲେଖିଛନ୍ତି 143
ठीक एटा अछि कि
नेक्स्ट पेज 7 रे
हां मु देख सारले माने एथर केतरा अछि एक्चुअली कोटा कोन तो
कॉलम 5(2)C ର सीरियल नंबर 1 4
1 then
4 and 5
4 ଆଉ ଗୋଟେ होची कौन से ऑफेंस टा कहले
143
143 हां 1 गोटे आ गोटे कहले 4
4 5
5
तीनटा केस पेंडिंग अछि
143 अच्छा से लिखंतु 143 तो ऑफेंस गुडा के ठीक कर दियंतु केस होची 3 to be taken in that is 2 सेटा होची 2 अच्छा सीरियल नंबर टा ठीक कर
ठीक अछि
1400 सेटा 143 to be pending against me. It's another omitted to me one more charge for the offense 120B to be এটা হচ্ছে 120B হবনি এটা হচ্ছে 143 against me answer so that the voters will know okay yes
ଏମିତି ଆପଣ କଲମ 5(2)D ରେ ଲେଖିଛନ୍ତି 2 charges under section 7/3 and 7/4 of PDPP Act is pending against you. Whereas in column 5(2)C ର serial 1 2 and 12 रे
1 रे गोटे अछि तापरे
2 Roman 2
हां 7 अछि तापरे
then 12
XII हां हां
3 cases pending against you.
PDPP 7 12 रे कोठी अछि 7 PDPP जे 12 तो नहीं 3 PDPP हाँ 3 अच्छा 3 टा भी अछि हाँ ओके हाँ PDPP एक्ट रो 3टा केस आपनकर पेंडिंग अछि बेली एठी लिखचंती सेठी लिखचंती 2टा हाँ ठीक अछि 2 charges related to mischief doing in respect of the public property 7(3) गोटे गोटे 7(4) गोटे किंतु
7/3
हाँ 7/3 हाँ 7/3 रो एक्चुअली दीटा केस पेंडिंग अछि 7/4 रो गोटे ऑलराइट कोन लिखले इट्स अ फैक्ट दैट हाँ सही अछि सेक्शन 7 7/3 कर दियंतु
7/3 and 7/4
हाँ एंड 7/4 कर दियंतु 7/4 of PDPP Act. Hala? It is a fact that though I have mentioned the offense also in 3 cases to be pending against me in column number 5 to C.
1,
Bhait serial number 1, tapare
2,
2 out
12.
12 achi. But I have mentioned in column number 5 to D that 2 seta hoji 2 charges. Tatale 2 charges under so and so were pending against me. I have omitted to mention one more charge under so and so to be pending against me on account of clerical error. Tapare suggestion dali asu. It is notified that I have deliberately omitted to mention one more charge for the offense under section to be pending against me in my affidavit in form to mislead the voter. Okay.
ଦେଖନ୍ତୁ ଆପଣ column 5 to D ରେ ଲେଖିଛନ୍ତି 2 charges under section 9 and 96 of
Urban
Police Act. Whereas in column 5 to C, serial 4, 5, 12,
XII or Urban Police Act. 3টা pending আছে
3টা case pending ଅଛି
কেইটা লিখଛନ୍ତି কি
2টা ଲେଖିଛନ୍ତି
লেখନ୍ତୁ I have mentioned 3 cases to be section ହଉଛି 9 and 96 of Urban Police Act. और UP Act ଲେଖୁଛନ୍ତି ତ
UP Act
और ଲେଖି ଦିଅନ୍ତୁ UP Act ଲେଖନ୍ତୁ ଚଳିବ UP Act in 3 cases to be pending against me in column number 5 in serial number ଟା କହିଦିଅନ୍ତୁ
serial number 4, 5, 12
अच्छा 4, 5 and 12 ହେଲା but I have mentioned 2 charges under section ସେଇଟା ଆସିବ ସେଇଠି ହଁ pending against me I have omitted to mention one more charge under section 9 and so to be pending against me on account of clerical. It's notified that I have deliberately omitted one more charge under section 9 and so on so to be pending against me to mislead the voters. Yes. I'm just within 1 minute I'm coming. Okay. Yes.
ଆପଣ ଯୋଉ ତିନିଟା ପେପରରେ ପବ୍ଲିଶ କଲେ ତିନିଟାଙ୍କ ପେପରରେ ସମାନ ଡିକ୍ଲାରେସନ ଦେଇଛନ୍ତି ନା ଅଲଗା ଅଲଗା ଦେଇଛନ୍ତି?
ଦେଖାନ୍ତୁ ମୋତେ।
ତିନିଟା ପେପରରେ ସମାନ ଡିକ୍ଲାରେସନ ଅଛି ନା ଅଲଗା ଅଲଗା ଅଛି?
I can. ଦେଇଛନ୍ତି ଭେରିଫାଇ କରୁଛନ୍ତି ତ ଓକେ ଇଟ୍ସ ଅଲ୍ ରାଇଟ୍। ଅଲଗା ଅଲଗା ଯୋଉ ଅଛି କି କିଛି ଏକା ତ ହଁ ନାଇଁ ସିଏ ଆପଣ ଯେମିତି ପଚାରିଲେ ସିଏ ଛାନିଆ ହେଇଯିବେ ନା କାଳେ କଣ ଭୁଲ ଭାଲ ହେଇଗଲା।
ହେଲେ କନଫର୍ମ କରିଦେବାକୁ ଦେବୁ।
About criminal cases in format C1 in 3 newspapers already marked as exhibit B by 1, C by 1 and D by 1. अच्छा
ଦେଖିଲେ ଏକ୍ଜିବିଟ୍ ଏ ଯୋଉ ଆପଣ ସିରିଆଲ ନମ୍ବର 1 ରେ ଲେଖିଛନ୍ତି ଜିଆର କେସ୍ ନମ୍ବର 27/22/2018
मनु सर्च पे टाइप करो हाँ
पेंडिंग अंडर सेक्शन 143
फिर टाइप करो
294 431 149 of IPC and 7/4 of PDPP Act.
Yes. Mention करजन. What is your question?
FIR exhibit 27, sorry, exhibit 17.
17 दियंतु. GR इटाला 1722. Yes, हाँ, बोल.
This FIR discloses this FIR has been registered under section 147, 148, 342, 450, 395, 332, 427, 354, 294, 506, 149 and 7/3 PDPP Act. ଆପଣ ପେପରରେ ମିଛ ଡିକ୍ଲାରେସନ କରୁଛନ୍ତି.
वो से ऑफेंस गुड़ा का सेकेंडरी लगाई जी.
1722 टा 1723 ହେଇଯାଇଛି.
ଆପଣ ଯୋଉ GR କେସ୍ ରେ ଯୋଉ
1722 of 2018 ରେ जो ऑफेंस गुड़ा का रजिस्टर्ड ହେଇଛି ସେଗୁଡାକ मेंशन ହେଇଯାଇଛି सीरियल नंबर 2 रे. 1 ରେ हबा कथा.
ସେ ଦୁଇଟା ଯାକ କେସ୍ ସେମ୍ ପୁରୀଘାଟ ପୋଲିସ
ନାଇଁ
ଷ୍ଟେସନର
ସେ ପୁରୀଘାଟ ର କିଏ ମନା କରୁନାହାନ୍ତି. ଗୋଟେ କୋର୍ଟ ରେ ବି ପେଣ୍ଡିଂ ଅଛି. ତା କେସ୍ ନମ୍ବର ଟା ଅଲଗା ନା. ତେଣୁ ସେ କହୁଛନ୍ତି ଯେ ଅଫେନ୍ସ ଯୋଉଡାକ ଦର୍ଶେଇଛନ୍ତି 1722 ଏଗେନଷ୍ଟ ରେ ସେଗୁଡାକ ଠିକ ଅଫେନ୍ସ ନୁହେଁ. ଆପଣ ଏକ୍ସପ୍ଲାନେସନ କଣ ଦେବେ ଦିଅନ୍ତୁ. ଅଫେନ୍ସ ତ ନୁହେଁ ଜଣା ପଡିଯାଉଛି ଏକ୍ଜିବିଟ 17 କଣ ପାଇଁ ଏଟା ମେନସନ ହେଲା କଣ ଆପଣଙ୍କର
advocate କହିବେ.
All right. Question कर दियो. Please verify exhibit B सेटा नहीं आसन कॉपी करी पेस्ट कर दियो. And see that in serial number 1 so far as GR case number 1722 by 18 which was pending in the court of SDGM Kotak nahi Sadar likha hai nahi SDGM comma Kotak. Please verify so and see that in serial number so and so which is pending so and so the offenses you have mentioned you have declared against such column are not correct. What do you want to say? What do you say? Stop. What do you say? Question mark. Answer. My advocates can only reply. Stop. Yes. Exhibit. Aja. Please verify article. Please verify so and see that so far as Juan so which was pending in even though SDGM Kotak comma set would even though exhibit 17 shows that exhibit 17 nahi nahi exhibit even though ta kar diyantu exhibit comma de comma but exhibit nahi exhibit 17 shows that the offenses you have declared against such column are not correct. What do you say? ठीक है सिला दो. Advocates can only.
ସେମିତି ଆପଣ ଯୋଉ ସିରିଆଲ ନମ୍ବର 2 ରେ ଲେଖିଲେ କ୍ଲିୟର କେସ୍ ନମ୍ବର 1723/2018 ର ଯୋଉ ଅଫେନ୍ସ ଲେଖିଛନ୍ତି ସେ ଅଫେନ୍ସ ଗୁରା ବି ଆପଣ ମିଛ ତଥ୍ୟ ଲେଖିଛନ୍ତି। ଏକ୍ଜିବିଟ୍ 18 ରେ ଯୋଉ ଅଫେନ୍ସ ରେ ଲିଷ୍ଟେଡ୍ ହେଇଛି ଆପଣ ସେ କରେକ୍ଟ ଅଫେନ୍ସ ନ ଲେଖିକି ମିଛ ଅଫେନ୍ସ ଗୁରା ଲେଖିଛନ୍ତି ନ୍ୟୁଜ ପେପରରେ।
18ଟା ଦିଅନ୍ତୁ। ହଁ ଏଇଗୁଡାକ ଲେଖିବା କଥା ଥିଲା ସେଠି। Same answer you don't give? Yes. Please verify so and so and see that in serial number 2, so far as GR case number 1723, that is 3 last 2 cut them, which was pending against same court. Exhibit 18 shows that the offences you have declared against such column are not correct. What do you say? My advocates can declare.
Against such column are false declarations. Not correct.
Acha, are such column against such column are false declaration. Declaration. What do you want to say? ऊपर टैब कर दें. False declaration are not. अताटे तोड़ो. हाँ, they are not correct. Are false declaration. होला. You have sentence study out पढ़िया. Please verify so and see that in serial number 2, so far as GR case number 1723, which was pending in the court of Exhibit 18 shows that the offences you have declared against such columns are false declaration. What do you say? Yes, my advocates can. Okay. All right.
Serial number 5.
5. SDGM Cuttack, GR number 1020/2012. कितने नंबर इटा exhibit 20 टा दियो.
ଶହେ ଅଠାଅଶୀ କୁ ଦେଖିଲେ ଜଣା ପଡୁଛି ଆପଣଙ୍କ ବିରୁଦ୍ଧରେ 188 ଦଫାରେ ବି ଗୋଟେ ଅଫେନ୍ସ ରେଜିଷ୍ଟର୍ଡ ହେଇଥିଲା. ଆପଣ 188 ଦଫାଟାକୁ ନ୍ୟୁଜ ପେପରରେ ଡିକ୍ଲେୟାର କରିନାହାନ୍ତି.
original accepted.
କୋଉ ସିରିୟଲ ଭିତରେ ପଚାରୁଛନ୍ତି?
Serial 5.
Serial 5.
188 ରେ ରେଜିଷ୍ଟର୍ଡ ହେଇଛି ସେ ଏଫଆଇଆର.
GR 110/10/2012 କୋଉଟା ଛାଡିଛନ୍ତି କହୁଛନ୍ତି?
ସେକ୍ସନ 188.
88 मेंशन ହେଇନି.
मतलब जहाँ affidavit थियो I think ସେଇଟା ହିଁ mention ହେଇଥିବ ଏଇଥିରେ. ସେଥିପାଇଁ affidavit ବି 188 ଆମେ ମୋର ମନେ ପଡୁଛି ଯାହା ବୋଧେ ମିଶି
କୋଉଥିରେ mention ହେଇଛି?
affidavit ଯୋଉଟା ଥିଲା 52IC ରେ.
affidavit ରେ ମାନେ ଯୋଉ 26 କଥା କହୁଛନ୍ତି? ନାଇଁ ସେ ପ୍ରଶ୍ନ ପଚାରୁନି. ଇଏ ଦିଟା କଥା ଦେଖୁଛନ୍ତି. ୟାର ଏଫଆଇଆର କପିଟା ଆପଣଙ୍କୁ କନଫ୍ରଣ୍ଟ କରୁଛନ୍ତି ଯୋଉଟା କି ଏକ୍ଜିବିଟ 20, ଆଉ ଗୋଟେ କନଫ୍ରଣ୍ଟ କରୁଛନ୍ତି ନ୍ୟୁଜ ପେପର ର 5 ନମ୍ବର ସିରିଏଲଟା. ସେଟା ହଉଛି ଏଇ କେସର GR 110/20, ସେଇଟାର ଗୋଟେ ଅଫେନ୍ସ ଟାକୁ ଛାଡି ଦେଇଛନ୍ତି କହୁଛନ୍ତି 188 ଟାକୁ. ସେଟା ଓମିଶନ ଟା ଯୋଉ ହେଇଛି କଣ ଆପଣଙ୍କର ଏକ୍ସପ୍ଲାନେସନ କହିଲେ ଲେଖିଦବା. Please verify so and see that in serial number 5, so far as GR case number 10/20/2005, which was pending in the court of SDGM, Cuttack, exhibit 20 shows that the offense under section has been omitted. Has not been declared. Has not been declared. Has not been declared.
In exhibit B1, C1, B1.
गला पर a not been declared in exhibit. कर दो in exhibit outer nation. In exhibit से उड़ा. What do you say? Please verify exhibit B1, C1 and D1 and see that in serial number 5, so far as GR case number 1020 of 2012, which was pending in the court of so, exhibit 20 shows that the offense under section 188 of the Indian Penal Code has not been declared in so. What do you say? See, my advocates can only reply. Okay. Yes. Also, period.
ଦେଖନ୍ତୁ ସିରିଆଲ ନମ୍ବର 6 ଆପଣ ଲେଖିଛନ୍ତି ସ୍ପେଶାଲ ଜଜ୍ ଭିଜିଲାନ୍ସ କଟକ GR ନମ୍ବର 85 2012 under section 147 341 323 294 353 427 149 IPC କିନ୍ତୁ ଏକ୍ଜିବିଟ୍ 23
ଦିଅ
ଦେଖିଲେ ଜଣା ପଡୁଛି ଏଫଆଇଆର ଟା 147 341 323 294 353 427 149 IPC ଦଫାରେ ରେଜିଷ୍ଟର୍ଡ ହେଇନାହିଁ ଆପଣ ଏଟା ମିଛ ଡିକ୍ଲାରେସନ ନ୍ୟୁଜ ପେପରରେ କରିଛନ୍ତି
ଏକ୍ଜିବିଟ୍ 23
ଆଜ୍ଞା
ଏକ୍ଜିବିଟ୍ 23 ଟା ହଉଛି VGR
ସେ GR ଲେଖିଛନ୍ତି ଗୋଟେ that is a mistake
ଆଚ୍ଛା
offenses he has mentioned
ରୁମ୍ ସେ GR କଣ ଲେଖିଛନ୍ତି କୋଉଟା କୋଉ ସିରିଏଲ ଯେ ପ୍ରଶ୍ନ
serial 6
6 ଆଚ୍ଛା
GR ବଦଳରେ VGR ଲେଖିଛନ୍ତି
ଓକେ ନାଇଁ VGR ବଦଳରେ GR
ବଦଳରେ GR ଲେଖିଛନ୍ତି offenses he has mentioned 147 341 323 294 353 427 149 IPC whereas this FIR has not been registered under these offenses
okay yes लिखिले please verify and see that in serial number 6 so far as GR number 85 by 12 Kordan Khali 2012 which was pending in the court of special judge vigilance Katak exhibit 23 shows that the case number is actually VGR number 85 oblique 2002 oblique 2012 and the offenses you have declared against such column are false declaration. What do you say? Same reply. My lord. Okay. Next.
ସେମିତି ଆପଣ ସିରିଆଲ ନମ୍ବର 7 ରେ ଏକ୍ଜିବିଟ୍
25 ଟା ଦିଅନ୍ତୁ
ଲେଖିଲେ GR କେସ୍ ନମ୍ବର 84 2012 ସେଟା 84 ନୁହେଁ ସେଟା VGR କେସ୍ ନମ୍ବର 84 2012 ଆପଣ ଏଟା ବି ମିଛ ଡିକ୍ଲାରେସନ କରିଛନ୍ତି
24 କେତେ ନମ୍ବର ସିରିଏଲ ପଚାରୁଛନ୍ତି 7 ଟା ହଉଛି GR 84 ଏଟା VGR वाला ऑफेंस ठीक ଅଛି अच्छा लिखो please verify so and so see that serial number so and so far as GR case number 84 of 2012 which was pending in the court of special judge vigilance Cutter, exhibit 25 shows that the case number is actually VGR 84 of 2012 সেটা কাটি দেন সেটা অফেন্সটা কাটি দেন and you have made false declaration You have made false declaration about the case. What do you say? Please verify so and see that in serial number so far as GR case number which was pending in the court of exhibit 25, so that the case number is actually BGR number 84 of 2012. You have made false declaration about the case. What do you say? Same reply. Aslam, my advocates can only reply. Yes, next.
The serial number 8 रे देखो हम लिखले GR number 83 of 2012 exhibit 1
about एक number. Click. कितना number?
24.
24. Eighty-three टाକୁ ଲେଖିଛନ୍ତି BGR टाକୁ ଲେଖିଛନ୍ତି GR. Offense ठीक ଅଛି ତ?
ନାଇଁ
ଆଉ
ଏଇ ଯୋଉ ଅଫେନ୍ସ ଆପଣ ଲେଖିଛନ୍ତି କେବଳ 32 read with 13(1)(d) of PC Act ଲେଖିଛନ୍ତି. Whereas this FIR has been registered under section 120B, 420 IPC and 32 read with 13(1)(d) of PC Act.
420 120B ଏଠି omit ହେଇଯାଇଛି. ଆଉ BGR ଟା ଆଇଅ. Okay, same ଲେଖନ୍ତୁ. Please verify S1 so and see that it has serial number 8. So far as GR number 83 of 2012, which was pending in the court of Special Justice Vigilance, Cutter, Exhibit 24 shows that the case number is actually BGR number 83 of 2012. And the offenses you have declared against such column are false declaration out and continue and offenses under section 420 and 120B of the Indian Penal Code, under which the case was actually registered, have not been shown in, have not been declared in the exhibit exhibit B1 C1 हाँ ऊपर नहीं है. What do you say? My advocate cannot. Other part of question. Please verify exhibit B1, C1, D1 and C that in serial number 8, so far as GR case number 83 of 2012, which was pending in the Court of Special Justice Vigilance, Cutter, exhibit 24 shows that the case number is actually BGR 83 of 2012. And the offenses you have declared against such column are false declaration and the offenses under sections 420 and 120B of the Indian Penal Code, under which the case was actually registered, have not been declared in Swansu. How do my advocates can reply? Yes. Yeah.
Serial number 9 there. Exhibit 27.
27 there. Hold on.
Serial number 9 ରେ ଆପଣ ଦେଖିଛନ୍ତି SDJM Bhubaneswar. Whereas that case was pending before JMFC O Bhubaneswar. ଏବଂ ଆପଣ ଯୋଉ ଦେଖିଲେ
न्यूज़पेपर सीरियल नंबर कितने?
न्यूज़पेपर सीरियल नंबर 9.
GR केस नंबर 680.
ଏଟା ଠିକ ଅଛି
2012 এটা জেএমএফসি ও জায়গায় এসডিজিএম নেইছে
SDGM এবং offences that FIR has been registered under section 417, 341, 323, 294, 506, 379, 123 of the 34 IPC. Whereas you have made a false declaration that this TR case is under section 420, 120B of IPC, read with 13.2, read with 13.1D of PCI.
all right click on please verify swan see that serial number 9 hala so for a GR case which was pending so exhibit 20 এটা kete number exhibit 27 exhibit 27 shows that the case was pending the case was actually pending in the court of JMFC O Bhubaneswar hala and the offenses you have declared against such column are false declaration and seti to pura false declaration karchen what do you say my advocates can only reply yes
MD upon a serial number 11, exhibit 21.
যেটা নিয়ন্ত্রণ exhibit 21
Serial number 11 is actually GR case 1168 under section 147, 148, 353, 332, 336, 37. এটা 37 हुए FIR টা হচ্ছে 337 এর রেজিস্টার
back to official level 1168 printing error 337 रे केसटा रेजिस्टर्ड ହେଇଛି ଆପଣ 37 ଲେଖିଛନ୍ତି ଦେଖିଲା ନା କଣ ଲେଖିଲା
ଆଜ୍ଞା
please verify as well as see that exhibit so far as GR case number 1168 of 2011 ଲେଖନ୍ତୁ ହେଲା which was pending in the court of SDGM S कटक ଲେଖନ୍ତୁ SDGM ନାଇଁ ଦେଖିଛନ୍ତି SDGM କଟକ ଖାଲି ଲେଖନ୍ତୁ SDGM କମା भुवनेश्वर में कटक भुवनेश्वर टा काटंतु हैला exhibit 21 shows that the case was registered not under section 37 of IPC but you have declared such offense
That's offense to be section 37.
say no you have declared such offense to be under section 37 of the Indian Penal Code in लिख दियो in से जो पेपर्स उड़ा करें in exhibit कहते जो हाँ and this and it was false declaration and it was false declaration but you and it was a false declaration but you say my advocates can reply yeah
out of serial number 12 रे आपण लिखले SDGM कटक
कितने नंबर से exhibit
এটা exhibit 22
yeah exhibit 22
this case was not pending before the SDGM Cuttack, whether this case was pending before JMFC City Court Cuttack.
City Cuttack, okay, right. Offense ठीक है
तो बाकी सब ठीक है
अच्छा ठीक है
you have made a false declaration in your
all right gonna see that serial number 12 so far a GR number 1568 of 2010 କରନ୍ତୁ ସେଟାକୁ 2010 which was pending in the court of JMFC City Kotak ठीक ଅଛି this one so GR case which was pending in the court of नहीं SDGM से देखे जाए कटी लिखो SDGM Kotak but exhibit 22 shows that the case was pending in the court of JMFC City Kotak and false declaration पर पड़े थे and you have made false declaration about the name of the court in से जो exhibit सुड़ाने है ना it was a false declaration काटी जानतु comma दियंतु what do you say my advocates can reply out a question टा पड़ेगा please verify exhibit B1 C1 and D1 and C that in serial number 12 so far as GR case number 1168 sorry 1568 11 नहीं এটা serial number 12 तो 12 ले 1568 है ना of 2010 which was pending in the court of SDGM Panso but exhibit 22 shows 22 ठीक है जी that this case was pending in the court of JMFC City Kotak and you have made false declaration about the name of the court. You have made false declaration about the name of the court in such and such. What do you say? My advocates can reply. Yes.
ये तो कहले आपनको वकील कहबे आपनक मतरे आपण एटा मिछ डिक्लेयर करछन्ती ना ठीक डिक्लेयर करछन्ती
एडवोकेट कहि
सेटा देखो
कोन हला
He answered my lawyers will say, in your opinion, whether you have made correct declaration or false declaration.
अच्छा question करो after verifying exhibit B1 comma C1 and the FIR and the corresponding FIR comma whether you can say that you have made correct declaration in these said exhibits question mark my advocate can reply
देखंतु आपण ए जो न्यूज़ पेपर रे पब्लिश करथले एटा माननीय सुप्रीम कोर्ट का डायरेक्शन 25 सितंबर 2018 अनुसार रे एटा पब्लिक करेक्ट डिक्लेयर क्रिमिनल केस गोटे कैंडिडेट का विरुद्ध रे जदि क्रिमिनल केस पेंडिंग थाए से ताहाले तार करेक्ट इंफॉर्मेशन तीनटा न्यूज़ पेपर रे पब्लिश करिवो एवं आपण जानी सुनी कि माननीय सुप्रीम कोर्ट का आदेश को न मानी कि मिछ तथ्य पब्लिश करछन
एमती गोटे डिक्लेरेशन थिबो बोली आपण जानिथिले तो एमती गोटे तीनटा न्यूज़ पेपर डिक्लेरेशन करिवा को पड़िबो गोटे कैंडिडेट नारे जदी किछि क्रिमिनल केस पेंडिंग थाए तीन ए कथा जानिथिले अच्छा आई न्यू about publication of criminal cases the details like that the details of I knew about the publication of details of criminal cases pending against a candidate in 3 newspapers. I knew about the requirement. I knew about the requirement of publication of details of criminal cases pending against a candidate in 3 newspapers. 3 अच्छा in कितना newspaper? अच्छा in 3 newspaper in 3 occasions. अच्छा ठीक है. In newspapers in 3 occasions as per the order of the Honorable Supreme Court. हाँ छाड़ दियन से कथा तो कोना सुप्रीम कोर्ट से से जानिछन्ती बोली कहउछन्ती. हाँ तीन थर पेपर रे पब्लिकेशन करिया पड़िबो डिक्लेरेशन करिया पड़िबो बोली से कहउछन्ती मु जानिछली एटा अछि बोली.
आपण तीनटा पेपर रे तीन थरे पेपर रे पब्लिश करिसंती किंतु आपण जो पेपर रे पब्लिकेशन करिसंती आपण को नार विरुद्ध रे जो क्रिमिनल केस पेंडिंग अछि तार सठिक तथ्य देनाती मिछ तथ्य पब्लिश कर टू मिसलीड द वोटर्स ऑफ द कंस्टिट्यूशन
उद्देश्यमूलक भाव से कहउछ डेलिबरेटली आपण फॉल्स डिक्लेरेशन देइछन्ती बोली कहउछन्ती. कोन आपण कहिबे एडवोकेट? अच्छा it's not a fact. Look, it's not a fact that I have deliberately made false declaration in the in the publications on each occasion as per exhibit से जो नया सुन सरा जो कौन हाँ B by function to mislead the voters of 90 Baravati Assembly constituency. हाँ बारावटी कटक Assembly constituency. Hala, stop. It is not a fact that I have deliberately made false declaration in the publications on each occasion as per so and so to mislead the voters of 90 Baravati Cuttack constituency. My advocates can only reply, say, reply me, my advocates can only say as to why there are omissions of offense na kono offense or case number case both अछि omissions acha why there are wrong mention why there are wrong mention about acha wrong mention about the criminal cases about the details about the details of criminal cases in exhibits B by 1, C by 1 and D by 1. My advocates can only say as to why there are wrong mention about the details of criminal cases in so and so. Yes.
And this is the appropriate place to record my objection. Yeah, and record.
हाँ बोधे आपण कहितले सॉरी
ତାଙ୍କର ଯାହା ପଚାରିବେ ପଚାରନ୍ତୁ ଏଇଠି ମୋର ଅବଜେକ୍ସନ ଟା
अच्छा ऑल राइट मेंशन ती ସେଟା ସବୁଗୁଡା मेंशन करिया पड़े ना सर
ନାଇଁ ନାଇଁ ମୁଁ ଖାଲି ଯାହା କହୁଛି very shortly exhibit 17 to 25 28 and 29
exhibit 17 to
25
हाँ
28 and 29
28 and 29
are beyond pleading
are beyond pleading.
And questions put with respect thereto are objective. ତେଣୁ କି ଆମେ
Okay.
argument
The ଲେଖନ୍ତୁ learned counsel bracket ଲେଖନ୍ତୁ learned counsel for the respondent objected to questions put by the learned counsel for the election petitioner with respect to exhibits कर देंगे yes 17 TO2 25 comma exhibit 28 and exhibit 29 comma टा काट दियन सेठी and 28 पर exhibit 29 in the cross examination as those are beyond pleading. अच्छा objected to all questions all questions put by the learned counsel for the election with respect to so and so in the cross examination as those are beyond the pleadings to cross examination to the respondent अच्छा to the respondent as those are beyond the pleadings. Okay. Yes.
ଆପଣ ଏ ଯୋଉ ଏକ୍ଜିବିଟ୍ D1 C1 D1 ରେ ଯୋଉ କେସ୍ ଡିକ୍ଲେୟାର କରିଛନ୍ତି ଏବଂ ତାର ଯୋଉ ଦଫା ଏଗୁଡ଼ା ଠିକ ବୋଲିକି କଣ କାଗଜ ମାନ୍ୟବର କୋର୍ଟରେ ଦାଖଲ କରିଛନ୍ତି?
ଆପଣଙ୍କ ତରଫରୁ କିଛି କାଗଜ ପତ୍ର ଦାଖଲ ହେଇଛି ଏଇ ଯୋଉ ଆପଣ ଡିକ୍ଲାରେସନ ତ କରିଦେଲେ ଯେ ଏଇ କେସଟା ମୋ ନାଁରେ ପେଣ୍ଡିଂ ଅଛି ଏଇ ଦଫାରେ ପେଣ୍ଡିଂ ଅଛି ତାକୁ ସବଷ୍ଟାନ୍ସିଏଟ କରିବା ପାଇଁ ବା ତାକୁ ପ୍ରମାଣିତ କରିବା ପାଇଁ ଆପଣଙ୍କ ତରଫରୁ ଏଇ ଯୋଉ ଏତଲା କପି ହଉ କି କୋର୍ଟର ଅର୍ଡର ସିଟ୍ ହଉ କି ଚାର୍ଜ ସିଟ୍ ହଉ ଏମିତି କିଛି ଡକୁମେଣ୍ଟ ଆପଣଙ୍କ ତରଫରୁ ଦିଆହେଇଛି ଏଇ ଯୋଉଗୁଡାକ ଦେଖଉଛନ୍ତି ଏଇଗୁଡାକ ତ ତାଙ୍କ ତରଫରୁ ହେଇଛି ଆପଣଙ୍କ ତରଫରୁ କିଛି ଦେଇଛନ୍ତି ଓକିଲ କହିବା ଅଛି I cannot say, no, I cannot say whether any document has been filed on my behalf to substantiate that the details of criminal cases as mentioned in exhibit से जो D and exhibit 43 से जो exhibit and जो से जो and 45 46 it has jata I cannot say whether I cannot say whether any document has been filed on my behalf to substantiate that the details of criminal cases as mentioned in so and so are correct. Stop. My advocates can only say about the same. Stop.
ଆପଣଙ୍କ ଓକିଲ କହିବେ ଆପଣଙ୍କ ଜ୍ଞାତ ସାରରେ ଆପଣ କହିବେ କି ଏ କ୍ରିମିନାଲ କେସର ସବୁ ଠିକ ଡିକ୍ଲାରେସନ କରିଛନ୍ତି ବୋଲି କଣ ଡକୁମେଣ୍ଟ କୋର୍ଟରେ ଦାଖଲ କରିଛନ୍ତି?
Put question once again.
ଆପଣ ଆପଣଙ୍କ ଓକିଲ କହିବେ ଆପଣ ଆପଣଙ୍କ ଜ୍ଞାତ ସାରରେ କଣ ଏଇ ଯୋଉ କ୍ରିମିନାଲ କେସ୍ ପେଣ୍ଡିଂ ଅଛି ଏଟା ଠିକ ବୋଲି କି ପ୍ରମାଣ କରିବାକୁ କଣ ଡକୁମେଣ୍ଟ କୋର୍ଟରେ ଦାଖଲ କରିଛନ୍ତି?
ଆପଣଙ୍କ ନଲେଜ ରେ କିଛି ଅଛି ସେ ବିଷୟରେ कौन डॉक्यूमेंट दाखल है
appeal रे थिला से अनुसार आमे डॉक्यूमेंट्स
हाँ
डिपोजिट
हाँ
या तांको प्रीडिंग रे थिला
हाँ हाँ
से अनुसार डॉक्यूमेंट सब डिपोजिट करा हैछि
हाँ
या
नहीं
प्रीडिंग
आपण
बारे थिला
हाँ
ताको करा हि नथि
ଆପଣଙ୍କର ଯୋଉ ଯେତେବେଳେ ସେ କହୁଛନ୍ତି ଆପଣଙ୍କ ଜ୍ଞାତ ସାରେ ତ ଏଗୁଡାକ ତ କହିଦେଲେ ଆପଣଙ୍କର ଆଡଭୋକେଟ କହିବେ ବୋଲି ଆପଣ ଜ୍ଞାତ ସାରରେ କିଛି ଅଛି କି ଯେମିତି କିଛି ଡକ୍ୟୁମେଣ୍ଟ ଦାଖଲ ହେଇଛି ବୋଲି ଯୋଉଟା କି ପ୍ରମାଣିତ କରିବ ଆପଣଙ୍କ ନାଁରେ କଣ ସବୁ କେସ୍ ପେଣ୍ଡିଂ ଅଛି କୋଉ ଦଫାରେ ପେଣ୍ଡିଂ ଅଛି କୋଉ କୋର୍ଟରେ ପେଣ୍ଡିଂ ଅଛି ଏମିତି କିଛି ଆପଣ ଜ୍ଞାତ ସାରରେ ଅଛି ଯେ କିଛି ଡକ୍ୟୁମେଣ୍ଟ ଆପଣଙ୍କ ତରଫରୁ ଦିଆ ହେଇଛି ବୋଲି
सर दिया हैछि कि मैं एग्जैक्टली कोई परिबिनी
अच्छा आई कैनॉट से एग्जैक्टली नहीं से तो लगे जाऊं आई कैनॉट से एग्जैक्टली what documents have been filed on my behalf by my advocates to substantiate advocates कर दिंदु एज कर दिंदु हाँ to substantiate that whatever have been mentioned in से जो नहीं आसुन से exhibits one so दीटा को नहीं आसुन से पूराटा नहीं आसुन ऊपर नहीं आसुन B1 to नहीं आसुन हाँ and so and so are correct declarations. Stop. Yes.
ଦେଖନ୍ତୁ ଆପଣ ଆପଣଙ୍କ ନୋମିନେସନ ସାଙ୍ଗରେ ଯୋଉ ଫର୍ମ 26 ରେ ଆଫିଡେଭିଟ ଦେଲେ ଏବଂ ଏ ଯୋଉ ପେପରରେ ଡିକ୍ଲାରେସନ ଯୋଉ କ୍ରିମିନାଲ କେସ୍ ବିଷୟ ଦେଲେ ସବୁ ମିଛ ଡିକ୍ଲାରେସନ ଦେଲେ ବୋଲି ଆପଣ କୌଣସି ଡକୁମେଣ୍ଟ କୋର୍ଟରେ ଦାଖଲ କରିନାହାନ୍ତି
ଯେହେତୁ ଏଗୁଡାକ ସେ କହୁଛନ୍ତି ଯେହେତୁ ଏଗୁଡା ସବୁ ମିଛ ଡିକ୍ଲାରେସନ ଥିଲା ଆପଣଙ୍କର ଆଫିଡେଭିଟ ଇନ ଫର୍ମ 26 ରେ ଏବଂ ତା ଛଡା ନ୍ୟୁଜ ପେପର ଡିକ୍ଲାରେସନ ସେଗୁଡାକ ସେ
डिनाई करूछि
okay it is not a fact that since I have made false declaration not only in say जो exhibit B and so on so and again yes but also in এই जो 43 टू 46 जानते comma therefore I did not file any document to substantiate the same. Yes.
ଆପଣ ଏ ଯୋଉ ପେପରରେ ଡିକ୍ଲାରେସନ କଲେ ଏବଂ ଏ ଫର୍ମ 26 ଯୋଉ ଆଫିଡେଭିଟର ଡିକ୍ଲାରେସନ କଲେ ଆପଣ କ୍ରିମିନାଲ ପୁରା ଆପଣ କିଛି କାଗଜ ପତ୍ର ଦେଖିକି ଲେଖିଥିଲେ ନା ଓକିଲ ମନ ଇଚ୍ଛା ଲେଖି ଦେଇଥିଲେ
माय लॉर्ड मुटे स्मॉल सबमिशन करिवे
बसिन को ना किछि नै प्लीज टेक योर सीट रिलैक्स पानी पिया कथा जदी पियंतु
माय लॉर्ड
हां ए जो
दिस फॉर्म 26
बीटा
एफिडेविट
जस्ट आउथर क्वेश्चन मु रिफ्रेम कर दूची
मु मैडम सर मुटे
दी प्रकार उत्तर आपण दउचंती जे गोटे होची मोर इट्स अ क्लरिकल मिस्टेक कोठी कहउचंदी टाइपोग्राफिकल मिस्टेक आउ कोठी कहउचंदी मोर एडवोकेट्स रिप्लाई देबे ए तीनटा प्रकार प्राय आपण आंसर दउचंती तांकर क्वेश्चन होची प्राय जे आपण केस नंबर भूल ले करचंती कोठी ऑफेंस को छाडी जाइचंती ऑफेंस टा को इनकरेक्टली मेंशन करचंती एई सब विषय रे तेणु वर्तमान से गोटे जनरल क्वेश्चन पचारुचंती एई जो विषय रे आपण जेतेबेले एफिडेविट दाखल कले ऑब्वियसली आपण सत्यपाठ करिकिनी दाखल करछन ना सेटा को एफिडेविट टा तेणु याकू माइन्यूटली आपण पढ़ापढ़ी करिकिनी देखिकिनी वेरीफाई करी ताकू दाखल करथिले ना किए कहिदेला बेली कि आपण वकील कहिदेला बेली दाखल जा कहिबे तो लेखाओ
माय लॉर्ड से हम वकील याकू प्रिपेयर करथिले सब कल्ला परे मु क्लासी पहुंचली नॉमिनेशन फाइल करिया पूर्व कहली सब जिन ठीक ठाक अच्छी और ओवरऑल मुझे देखी दी गली मो बैकअप नॉलेज थिला मो नारे 13टी केसेस अच्छी 6टी विजिलेंस केस 7टा जेन्युइन इलेक्शन एजिटेशन केस सो 13 केसेस देखी दी गली ठीक थिला सो अकॉर्डिंगली आई साइन द डॉक्यूमेंट्स एंड आई सबमिट करलु बट क्लेरिकल मिस्टेक जेटा मो नजर के पड़ी नथिला तेणु मोर ओवरऑल जे मु ता कहती सब तो केस डिस्क्लोज करिवो तो मु देखिची सब तक डिस्क्लोज हेची बट अनफॉर्चूनेटली
13टा केस डिस्क्लोज हेची देखिले किंतु बाकी जो डिटेल्स गुड़ाक देखिवा कथा
डिटेल्स भी सर
सेगुड़ाक सेमानकर
खाली टिके माइनर कोठी एपटू सेपटू चल
हाँ से सेया ही
ସେଇଟା
कहउछन्ती जे सेटा आपण डिटेल्स टा वेरीफाई करनथिले
ठीक से
तांको
मु
कथारे पडिकिनी बा
कथा
एडवोकेट
पड़ी नहीं मु देखिदेली ओपन ठीक अछि बट से जो दफा सबू मैच करेवा कथा
हाँ सेटा
सेटा ठीक से
सेटा करि पारना अच्छा
बट सबू मु ऑनेस्टली डिस्क्लोज
ओके
करके या छडा मु पाखरे कौन सी केस नहीं कि ये दफा ऊपर आ कौन सी दफा
सब पारा एट द टाइम ऑफ फाइलिंग नहीं एट द टाइम ऑफ नहीं कर दियो देटा एग्जिबिट्स 43 44 45 and 46 है ना we are prepared by my advocates before नहीं सेटा कंटिन्यू करियो बिफोर फाइलिंग ऑफ द सेम with the returning officer. Stop. After its preparation, comma, I overall gave a look into it and found that pendency of 13 cases
pendency of all 13 cases
all 13 pendency of all 13 cases against me have been mentioned in it and so also the offenses and names of the courts where it was pending, where those were pending. It was not pending, where those were pending. Stop. At that point of time, comma, I had not verified the details of the offenses under which the cases were registered. So also the court names court names, name of the courts. Okay, name of the courts.
My lord, I had not minutely verified.
अच्छा, I had not minutely कर दें. What would login? I had not minutely verified the details of the offences under which the cases were registered. So also the names of the courts for which, names of the courts for which such omissions oblique
addition
such omission oblique additions or wrong mention कर दें तो wrong mention have been made which was not deliberately made to mislead the voters of 90 Baravati Cuttack Assembly constituency. ये तो अपन No, are you feeling uneasy?
Sorry,
से सुनନ୍ତୁ मिस्टर गोटे
My lord,
witness ମାନଙ୍କର state of mind କାରଣ ସିଏ ସେଠି ତାଙ୍କର ବ୍ୟତିବ୍ୟସ୍ତ ହଉଥିବେ, ସିଏ ଆପଣଙ୍କର କ୍ୱେଶ୍ଚିନ୍ କୁ ଠିକ ସେ ଫଲୋ କରିକିନି ଆନ୍ସର ଦେଇ ନ ପାରିବେ, ତାହେଲେ it would not be proper. He is feeling uncomfortable, so I am adjourning the case to tomorrow. Okay. Acha. So day after tomorrow at 2 o'clock. Okay. So cross examination is deferred to that is deferred to 31st August at 2 o'clock.
Pardon my lord. Item 142 of weekly is permitted to withdraw.
Withdraw.
Oblige.